It is not is
Keep the
My lord,
Okay.
item 99. It's a hearing matter. I have missed the file, my lord. Some other
who is the other side?
state is the other side. Criminal revision matter.
Criminal division. Note it down.
99.
Yes.
2012 matter. Miss.
I don't know कि mention my lord. One bail matter my lord. Yesterday I have mentioned my lord. One bail matter I have filed an IA. On ground that her uncle was expired on 6/3 of 2023 my lord, and his Sudhi ceremony is 15 March my lord. And this matter taken up tomorrow my lord. The present person is only one son of his family my lord.
Give a copy. He'll let him verify, and if verification report comes, then I'll take it up. Give a copy to Mr. Prabha. Yes.
Yes my lord. In course of obliged.
Yes.
My lord, pardon to mention, I'm mentioning out of list. My lord, this is a CRLMC 727 of 2024 disproportionate assets case. We have moved for quashing. The FIR is of 2013, and the investigation is not complete, and the charge sheet has not yet been submitted.
Give a copy.
Obligation.
May I please, last?
Yes.
Case of 302.
CD.
Outline.
Yes. Also.
21.
Yes. Also.
22. 23. 24.
May I please also? I am remand custody since 17/5/2023. Offense under section 457 380 of IPC my lord. In this case, the unknown FIR registered 26/11/2022. In this case, petitioner arrested one court part PS case number.
What is the stage of the investigation?
Investigation going on, madam.
No, madam. Already I have annexed charge sheet already filed, man. Page number 22, madam.
20.
Page number 22. What's in a petition annex?
Copy dina?
No, charge sheet annex for item 24.
What are the allegations?
Allegation unknown person are taken.
6 CA against the criminal antecedent against the person.
There is a remand case, man.
There is requirement or do the yes, sir.
Case that call for it.
My lord, in this case, yesterday, my lordship.
Let us see the case diary. 36 cases are against you.
Yes,
Let us
ma'am.
see.
My lordship, yesterday, one bail application 1257/2024, Arjan to 28/3/2024, man.
28.
Similar,
Going.
no, same person.
Same person.
Same person.
Outside.
BLPL number 1257.
28 March.
1257 of 2024.
28 March, 20 April.
No, 28/3/2024.
Urgent.
25.
Offense is 457 380, madam.
Sorry?
457 380.
Yes.
Offense. Allegation, madam. This petition took away 7 lakhs from the ATM, madam.
ATM.
ATM.
How many cases are there?
Rejection of so, my lord.
Yes, Mr. Ragada.
Some cases are pending.
Some cases, my lord.
Huh.
But if case diary will come, my lord, I will verify.
Case
How many
date,
cases
case
against
date. Yes.
26.
May I please, your lordship, my lord. Allegation under section 457 380 511 34 of IPC, my lord. Allegation, my lord. Some miscreant entered to the ATM counter and broke the door, attempt to commit theft, my lord.
Including you.
My lord,
Including you.
my lord, affair was unknown, my lord.
Obviously.
Affair was unknown,
Huh.
but
Investigation.
In progress, my lord.
completed.
No, no,
Charge
no.
sheet filed.
I just think.
How many cases are there against you?
ମୋର ନାଁରେ କୌଣସି ଆଣ୍ଟିସିଡେଣ୍ଟ ନାହିଁ କେବଳ ଏଇ କେସ୍ ରୁ ଆଉ ଗୋଟେ ନେଇଛନ୍ତି ଆଣ୍ଟିସିଡେଣ୍ଟ
So far, petitioner 1 is concerned. 4 criminal antecedents.
ରିମାଣ୍ଡ ନେଇ
Accidents.
କରିଛନ୍ତି
And petition 2 is concerned to another case, my lord, that is item 31, my lord.
there is a ରିମାଣ୍ଡ କେସ୍ ମାଇଲର
CD is required in both the cases.
ଆ ପାଖରୁ ରିମାଣ୍ଡ ନେଇଛନ୍ତି ଅନ୍ୟ କେସ୍
CD,
For
let us
all the
see.
cases, my lord, ATM, my lord.
Oh,
ATM.
ATM, sir. It's dangerous. These people are,
Well-
you know. Call for CD.
ମାଇଲର
Call for CD. Let us see.
ଆଇଟମ 31 also same
31 now.
Same petition.
same person
31 and CD. Yes.
27.
May I please? 1 kg and 560 gram of ganja.
Sorry.
1 kg and 575 gram ganja.
1 kg.
My lord,
Ganja.
my lord. And a similar
1 kg ganja. Antecedent.
similar nature no
My
answer.
lord, the lower court will
Will
verify
verify.
similar answer.
And the 23 also same 1 kg
20
23.
1 kg.
1 kg 180 gram.
or 23 भी शेयर कर दो 23
Hello.
हाँ allow कर दो 1 kg
My lord.
गंजा
My lord.
My lord, my lord.
No criminal similar nature.
29.
29 prisoner custody Belgium case my lord. They were released arrested on 28/4/2015 my lord. Prisoner 2 released on bail 26/5/2015 and prisoner released on 1 released on 9/9/2015 my lord. Individual issued on 17/1/2024 my lord and arrested on 12/2/24
give the dates once again
my lord.
petitioner was on bail on
Petitioner was petition number 1
and
released
now this is a bail application
my lord.
right now
Individual issued my lord.
petitioner is
Out of my lord 14 witnesses,
Huh.
13 witnesses have already been examined, my lord. Only IO left, my lord. For that reason, they did not cooperate the.
I will appear my
For
lord.
that reason,
what are the offenses
372. Other offenses.
so at this stage
If petitioner was on
Only IO
bail,
left, my lord.
Your
Only
Lordship,
IO.
petitioner was on
Expedite
bail.
the trial, otherwise
Ah, yes,
again
They
you
will
will
go
have.
again.
Your Lordship,
once your bail is granted you will be
Yes.
no,
Yes.
first time default my lord. First time default my lord.
ଆଉ ଗୋଟେ ତ ସାକ୍ଷୀ
And
ଅଛି
pay-
ନିର୍ଦ୍ଦୋଷର ଖଲାସ
And petition number 2 नारे 506 RC submitted 506
the material has come against him
5 nothing else.
କିଛି ଆସିନି, କେବଳ rejection ହେଲା। First time release.
They were on bail my lord since 2015 my lord 2015 ରୁ 2024 ପର୍ଯ୍ୟନ୍ତ appear କରୁଥିଲେ 24 ରେ first time ତେର ସାକ୍ଷୀରେ appear କରୁଛୁ ସବୁ ଡେଟରେ appear କରୁଛନ୍ତି is not in the Belgium no if second time Belgium
give me the dates
yeah my lord
give me the
my lord
No, the lower court, my lord, while rejecting, but on most of the occasion, they remain absent and were represented by their advocate.
they repented their advocate my lord
376 executed
no 506 my lord petition number 2 is the 506 my lord
Maybe pardon my lord.
Petition, my lord.
how many petitioners are there
2 petition my lord
ଜଣଗଣରେ 506 ଆଉ ଜଣରେ
376.
I may be
I will both will
I may
appear
be
my lord
pardoned,
try to conclude the trial my lord no second time Belgium first time Belgium my lord 15 ରୁ 24 ପର୍ଯ୍ୟନ୍ତ appear କରୁଛନ୍ତି
you got bail both of you
my lord bail they were arrested first 28/4/2015 my lord
28 4
2015 arrested petition number 2 release on bail 26/5/2015
petition number 2 release on bail
26/5/2015 my lord and after charge sheet my lord petition number 1 release on bail 9/9/2015
petition number 1 99
2015
2015
NBW issued on 17/1/2024
17 1
2024
arrested
12/2/2024
arrested 12 to 20 ये date लिख दो ना तो लिख दो and the next paragraph the both the petitioners moved the bail application before the court below the by the order dated 12/2/2024 the bail applications were rejected on the ground that in the most of the date of hearing the petitioner remained absent. Next
And they also violated liberty granted to them.
and
You cannot direct them, each and every day they will appear in.
right
physical like that.
and remain absent and they have also violated the terms of the condition of the bail condition of the bail. Next paragraph. On instruction, then counsel for the petitioner submits that no, Mr. Raghuda appeals for the state and submits that all the prosecution witnesses except the IO has already been examined. So therefore, at this stage, the petitioner should not be enlarged on bail. Next one, on instruction, then counsel for the petitioner submits that the petitioners will not default in appearing in the court, and undertakes that on each and every date of hearing, they will be appearing before the court below, so as to conclude the trial as expeditiously as possible. Bail review granted bail with all conditions, with further condition that in the event of a singular absent in the court during the trial, the concession granted by this court will be withdrawn.
One of the family member like father, mother, brother, sister shall be surety.
And the trial court shall also one of the family members of the petitioner shall stand as a surety.
Yes.
Stand as a surety while granting, while enlarging.
Right.
Obliged.
While single absent,
Madam.
your bail goes.
May I please, Madam, Operational Section 20B 2B of anticipation. 12 kg petition are outsider, madam.
30? Yes.
12 kg, both are outsider.
Both are
Outsider.
Chhattisgarh. Same condition. Yeah.
Same outsider. Huh?
24 of January 2024 custody.
Okay, 12 kilo, huh? 12
12
kg.
kg.
12 kg. 12 kg outside.
One jail custody 12 to the 4-2. Custodian I have mentioned 12 to the 4-2.
4-2.
4-2.
4-2.
24.
20.
And they also come in the item 30 manner. The investigation is going on. They will appear before the IO.
30 investigation is on. They will go for it. 32. First. 33. 34. 35. 35. Why nobody is coming here? Indication is there or not?
Yes, sir. Always. Nothing there.
Ready, Jana?
36.
Yes.
37.
38.
8 may I please.
307 along with other offenses, my lord. Omnibus allegation. Yesterday, one of the co-accused of similar putting as released on bail by this annual court.
Where is that order? Yes, Mr. Rao.
My lord, your lordship may kindly have a glance to the order of rejection, my lord. Of land 40 kilo, my lord.
Yes.
Last but 4 line, my lord. It is further alleged that while the informant was preparing the schedule list, the accused raised Tola, the petitioner and co-accused persons arrived at the spot being armed with lathi amid the police personnel in obscene languages, assaulted them and outraged the modesty of the informant in order to escape accused Gundu and accused Deepa and Hadia also snatched the mobile phone of ASI, and the involvement of this petitioner alleged the crime. The petitioner is involved with and attacked to the
How many?
Only 307.
Antecedents?
Incident at the time of reading the exercise.
No, antecedent.
Antecedent, my lord, that's not first time coming.
The co-accused has not been contributed.
Yes.
about the paragraph below, by order dated 11/3/2024, while allowing the bail plea of co-accused, being BL number 1/2/17/2024, this court has granted bail to the co-accused. Put paragraph below and put this below.
39.
376,
May I please, your lordship,
Notice.
pray for next
Notice
week,
to-
my lord. And notice suit required because.
Notice I have issued all. Notice.
extra copy will serve.
Notice, serve the copy with date of the 2 weeks. Yes.
40.
May I please, lordship. Yesterday, your lordship has allowed bail application of same present petitioner. Lordship, present petitioner was arrested on 18/10/2023.
No, another case.
Another case, lordship, while in custody, remanded in 4 cases, and all cases has been released on bail by this honorable court and other court bench.
CD says required, my lord, because there is the robbery of 90,000 rupees on the point of the gun, my lord. And the CD says well requested investigation of this case is under progress. my lord.
Get CD, 2 weeks. के बाद में. Yes.
41.
Madam, please, lordship.
Yes.
And offense under section 392 by 34 of IPC, my lord.
Hmm.
Already money has been recovered from the present petitioner, my lord. Petitioner is in custody since, my lord, 9/1/2024, my lord. And he is suffering from kidney disease, my lord. A young boy, my lord.
Where is the
Annexure 3 series, my lord, medical law.
you're asking for entry? Investigation is on.
My lord. Money recovered, my lord. No one antecedent, my lord.
Money recovered, therefore your involvement
lord.
is confirmed. Money recovered means the involvement is confirmed. That's what you want to say. Yes. Investigation is on.
My lord.
Because you have kidney disease. Huh?
My lord, Annexure 3 series, my lord. Since 21,
How much?
I am under
How many
treatment.
days you take to conclude the
Information, my lord.
investigation? Very,
Jajpur,
very
my lord,
good.
whatever may be your lordship, my
Meenakshi
advice.
Hospital.
Judge,
My lord.
What is this Meenakshi Hospital? Where from you got it?
Ganjam.
Huh?
Ganjam.
item number, which item?
41.
41.
51.
Where is kidney disease? Where is that?
Since 21.
Where is that?
Last, my lord, page 40, my lord. Last report, 3/11/2023.
Disease suffering from?
It says kidney damage. Where is that? Where will I get?
कोठी अच्छी कितना पेज रच
Yes. You tell me you have filed so many medical documents. You
Right.
know one relevant document where I can get that you have a problem, kidney problem.
There is no specific document.
You show me filing 1,000 documents without relevancy. You show me one document where I can get that you have a kidney problem. Some Meenakshi Hospital, I don't know who is this, whether he is doctor or not is doubtful. You file how many pages? Just see 30, 40 pages document you have filed. Show me one line where adjourn it. You prepare it. Come. Yes, next.
42.
I would have allowed you on interim bail and you are not prepared.
May I please, your lordship.
I was thinking of allowing you in interim bail so that investigation will be complete and sure. And you show me something.
This is a
You
transfer
have
bill.
document.
My lord, this is a transfer bill. My lord, next week, my lord.
Yes, but give it after 2 weeks. Yes.
May I please, your lordship. My lord, offense under section 52A of Orissa Excise Act 2008, my lord.
What is recovered?
Country liquor, 1,000 liter of country liquor from
vehicle, petition
1000 liters.
liter of country.
Curious. Have you?
No,
My lord, the
Exam-
C report has not been,
Huh?
C report has not been received, my lord. This is the first time coming.
When it is expected?
My lord, 1 week,
Next week. Sir. Next week. Notice next week. Okay. Awaiting chemical analysis. Yes.
43,
43.
43, 44,
44 my lord, 20B, 2B my lord, NDPS Act, 8 kg of ganja seized from the petition.
80.
8, no, 8,
08.
08.
8. Right.
Hon'Ble.
45,
Offense under sections 341.
Mm-hmm.
So offense under section, your lordship, 341, 376 to N and 506, your lordships. The petitioner is 20 years old, your lordships, and the informant is 32 years old.
Whatever you file, nobody can read it.
Yeah, lordships, I pray for the interim bill because the student petitioner is the 20 years and he is the final year student of +3.
Whatever you filed, I can't read anything. I can't read anything. FIR also is not legible at all. Not a single word I can read. 376 to N.
no.
This-
Sir, exam వచ్చేసి 15 tarik, sir. Interim bill, sir, exam వచ్చి 15 tarik, sir. Thanks.
FIR allegation is very serious, my lord.
So only interim bill, sir, for appearing for examination, sir.
Exam also set up on.
So କହିଛି ଦେଇଛି, sir.
Set up on, sir, my lord.
From 15th onwards, his examination starts.
Yes.
What are the allegations? Pascal?
So 341, 376 to N and 506, your
The
lordships.
age of the girl,
32 years, sir. Married woman, your lordships.
married woman.
Yes.
Let us read it at least. I can't read it, but at least tell me so that I can write it. What's the allegation?
ମୁଁ ଜୟଶ୍ରୀ ମାଳ ମଲ୍ଲିକ, ବୟସ 32, ସ୍ୱାମୀ ସୁଶାନ୍ତ କୁମାର ମଲ୍ଲିକ, ଗ୍ରାମ ଜଙ୍ଗଲା, ସଦର ଓ ସାକର, ଥାନା ଖଜୁରୀ, ଜିଲ୍ଲା କନ୍ଧମାଳ, ଲେଖି ଜଣାଇବା ଦରଖାସ୍ତ ମୁଁ
No, not at all. This is only the relevant part is, my lord. ମୁଁ ମତେ ସେ ଖବର ରଖି ମତେ ବାଧ୍ୟବାଧକତା ଭଲ ପାଇବାକୁ କହିଲା, ମୋର ମୋବାଇଲ ଫୋନ ନେଇ ମତେ ପ୍ରକାର ବିଭିନ୍ନ ଅଶ୍ଳୀଳ ଭାଷା ଗୁଡିକ ମେସେଜ କରି ଆସେ, ମୁଁ ବିରୋଧ କରେ ଏବଂ ସେ ମତେ ମାରିଦେବାର ଧମକ ଦିଏ। ବିଗତ 21 ମସିହା ଏପ୍ରିଲ ମାସରେ ମୁଁ ବିଲବାଡି ଅଙ୍ଗନବାଡି ସେଣ୍ଟରକୁ ଦିବା 10 ଘଟିକାରେ ଯାଇ ଫେରିବା ସମୟରେ ମତେ ବିଲାବାଦରୁ ଗାଡିରେ ବସାଇ ଜବରଦସ୍ତ ଡାହାଣ ପଟ ଜଙ୍ଗଲକୁ ନେଇ ମତେ ଦୈହିକ ସମ୍ପର୍କ ରଖିବାକୁ କହିଲା। ମୁଁ ବିରୋଧ କରିବାରୁ ମତେ ଛୁରୀ ଦେଖାଇ ହତ୍ୟା ଧମକ ଦେଲା। ଏହାପରେ ମତେ ଜୋର ଜବରଦସ୍ତ ଦୁଷ୍କର୍ମ କଲା। ଏକଥା ତୋ ସ୍ୱାମୀ କି କିମ୍ବା ତୋ ସମ୍ପର୍କୀୟ କାହାକୁ କହିଲେ କହିବୁ ନାହିଁ, ଯଦି କହିବୁ ତୋ ସ୍ୱାମୀ କିମ୍ବା ପୁଅ ଝିଅ ମାନଙ୍କୁ ଜୀବନରୁ ମାରିଦେବି ବୋଲି କହି ଧମକ ଦେଲା। ଏହାପରେ ମତେ ଏଣେ ତେଣେ ନେଇ ଦୈହିକ ସମ୍ପର୍କ ରଖିଲା। ପ୍ରତି ମାସରେ ମତେ 5-6 ଥର ମୋ ସହିତ ସମ୍ପର୍କ ରଖେ। 7 ଥର ସକାଳେ ସମୟ 9 ଘଣ୍ଟା ବେଳେ ଅଙ୍ଗନବାଡି ସେଣ୍ଟରରୁ ମୋ ସହିତ ମିଶିବାକୁ କହିଲା। ମୁଁ ମନା କରିବାରୁ ଗତ 7/1/20 ତାରିଖରେ ଅପରାହ୍ନ 3 ଘଟିକା ବେଳେ ମତେ ଫୁଲବାଣୀ ଷ୍ଟାଡିୟମ ଠାରେ ତାର ସାଙ୍ଗ ଘର ଫୁଲବାଣୀ ଗୋଦାମ ପାଖ ଘରକୁ ଯିବାକୁ କହିଲା। ତା ମଧ୍ୟ ମୁଁ ମନା କଲି। ପରେ ମତେ ତୋ ଘରକୁ ଆସି ତୋତେ ତୋ ଘରେ ଡ୍ୟାନ୍ସ କରିବି ବୋଲି କହି ଗତ 5/1/20 ତାରିଖରେ ଦିନ ଅପରାହ୍ନ ସମୟରେ 8ଟା ବେଳେ ମୋ ଘରକୁ ଆସି ମୋ ସହିତ ଦୁଷ୍କର୍ମ କଲା।
All allegations are serious. What to do? Can you verify the examination?
No, I have to verify, my lord.
Verify it and today is 12th. Huh?
Yeah.
Put it on 14th. 13th. Tomorrow only. Because 14th.
Yes, my lord. Yes,
15th is exam.
yes, my lord.
Tomorrow if he is
Today,
for entry bail,
yes, my lord.
at least he can appear in it.
Obliged.
Tomorrow. Verify and tell me. Yes.
46, 46, 47, 48,
May I please your lordship, my lord?
Yes.
Petitioner is custody since 8/11/23, my lord. The main allegation against me, my lord, annexure 1, Page 12, my lord.
Where you are?
Main only.
Raghunam Behra,
Yes, ma'am.
23. Yes.
Only allegation against me ki on 1/11/23.
Let us see 164.
Yes, my lord. Annexure 2, my lord.
Yes.
Page 14.
Raghunam Behra.
My lord, victim is my lord, my lord. The age is 16 years, my lord.
17 plus.
16 years as per a school examination, high school
Pokso
certificate.
is not involved.
No, my lord.
Now they will do it.
Sorry, my lord.
Now they will do it. Now
No.
charge sheet is filed, huh?
Yes, POSCO is there, my lord.
Pokso is there, huh?
Yes.
6 and 14.
Yes, my lord.
164 is there, my lord.
That's
161
right,
and
I have
64 is
read
there,
it.
my lord. So CD may be called for, my lord.
In the 164, she is implicating too.
Yes, yes, she's alleging incident took place before 3 years, my lord.
Whatever.
Thereafter continuous.
Call for CD, let us.
Let's sorted me fixed, well, because CD is not coming and they will not come. Send, my lord. Because ASR otherwise engaged in the election.
So far, whatever document you have
Yes,
filed,
yes.
you are not entitled to bail. If the CD comes, we will find out if anything is there, I'll give bail. And you have filed the document which are against you.
These allegations against 3 years
So
before,
that,
my lord. Only
POCSO is
allegation.
there,
Yes.
IT Act is there, 376, 2N is there, and the
376.
girl is 17 years. How, what do you expect?
376 before, my lord.
Pass or after 2? Yes.
49.
Can check now next week, my lord.
49 adjourned.
50.
May I please?
Yes.
The present petitioner is the father-in-law, my lord. And though the FIR was lodged initially under section 498A, 304B, 302, but subsequently charge sheet has been filed under section 498A, 306 and 304B.
Where is the charge sheet?
Charge sheet is with my charge sheet.
CD was called?
Yes, yes.
Yes, my lord.
304.
Yes, my lord.
304B, 306, and present petitioner is the father-in-law, my lord, and he is inside custody since, my lord, 18/12/2023, and the cause of death is, my lord, suicidal anti-mortem hanging.
304B or 306?
Both, my lord, 304B, 306, and husband is inside custody.
My lord, 304B, 306.
You are
my
husband
lord.
or what?
498.
No, my lord, I am father-in-law, my lord.
What are the allegations against you?
The allegation is omnibus.
Where, charge sheet is not there with me.
Charge sheet is mobile.
Where will I get all these things?
Charge sheet is with my learned friend.
FIR, you have not filed anything.
Well, charge sheet is with my learned friend, my lord.
Charge sheet is.
If my lordship will peruse, then I can give a physical copy.
It should come on record. On what basis I'll grant the bail? On the basis of FIR, I'll give. At least file that on the record.
A charge sheet is with my learned friend, my lord. He can assist. The charge sheet has been filed on 10/11/2023.
Bring it on record. Charge sheet. File the charge sheet next week. Yes.
498, 304.
That's right, but I need to know. At least you should have filed the charge sheet. You have that charge sheet.
My lord, this is the Xerox copy, my lord.
No problem.
I could not file it. This is not an authenticated copy, my lord. Authenticated copy is with my learned friend, my lord.
You file that, whatever you have, file it.
ଟିକେ ଆଜ୍ଞା ଦେଖିଦିଅନ୍ତୁ ରହିଲାଣି ବୁଢାଟା
Investigation of Buddha specific line.
ବୁଢା ଲୋକଟା ରହିଲାଣି
50, huh?
58 item 50
What is your age?
58, my lord.
58, Buddha look.
Young father-in-law.
I'm a young father.
Young father-in-law.
See whether any allegation against the father-in-law is there.
But he was demanded for the demand.
Demand, forget it. Anything else.
City, my lord, 498, 306, 304B, section 4 DP Act, my lord.
Read the content.
My lord, I am reading out, my lord. For a report, Sangram Malik, general report esteem Kedanapur, to face trial in the court, search for other chances to witness the accused persons, but no clue obtained. Made a prayer before the Honorable SP Kedanapur for CDR and SDR of mobile numbers of the accused and victim. Received PM report. This is from
If you read so many things, then
my lord, point that the cause
pass over.
could have been due to
Pass over.
my lord.
Prepare and come back. Tell me the exact what is the allegation. You will not assist this much, then how can?
No, my lord, I can assist, my lord.
What is the allegation you are not able to tell?
My lord, the allegation is omnibus in nature, my lord. Allegation is only with regard to demand of dowry.
Read that part of
My lord, just I am reading that part, my lord. My lord, they opined that the cause of death of the deceased could have been due to combined effect of asphyxia and venous congestion, and as per the medical report, it is suicidal in nature. And the present petitioner, being the father-in-law, allegation is that ସେମାନେ ଯୌତୁକ ବାବଦକୁ 1 ଲକ୍ଷ ଟଙ୍କା 10 ଭରି ସୁନା ଓ ଆବଶ୍ୟକ ସରଞ୍ଜାମ ନ ଦେବୁ ତାହେଲେ ଆମ ଝିଅକୁ ସେମାନେ ମାରିଦେବେ ବୋଲି ଧମକ ଦେଲେ। ଆମେ ଅତ୍ୟନ୍ତ ଗରିବ ଲୋକ ହୋଇଥିବାରୁ ଦାବି ମୁତାବକ ଯୌତୁକ ଦେଇପାରିବୁ ନାହିଁ ବୋଲି କହିଥିଲୁ ଓ ଝିଅକୁ ଫେରାଇ ଦେବାକୁ ଅନୁରୋଧ କରିଥିଲୁ। ଆସାମୀମାନେ ଆମ ଅନୁରୋଧକୁ ପ୍ରତ୍ୟାଖ୍ୟାନ କରିଥିଲେ। ସେଇଥିପାଇଁ ଆସାମୀମାନେ ମୋ ଝିଅ ପ୍ରତି ଶାରୀରିକ ମାନସିକ ଅତ୍ୟାଚାର କରି ଗତ ରାତିରେ ଜୀବନରୁ ମାରି ଶେଷ କରିଦେଇଛନ୍ତି। ଆମକୁ ଖବର ମିଳିଲା ପରେ ଆମେ କେନ୍ଦ୍ରାପଡ଼ା ସରକାରୀ ଡାକ୍ତରଖାନାକୁ ଆସି ଦେଖିଲୁ ଯେ ଆମ ଝିଅର ମୃତ ଶରୀର ପଡ଼ିଅଛି। କିନ୍ତୁ
death by hanging.
Death by antemotum suicidal hanging.
ଖାଲି mother of disease ପଢି ଦଉଛି।
ଖାଲି PM ରିପୋର୍ଟଟା ଦଉନା।
Mother of disease।
Mother of disease।
ନା ହଁ ମାଲଡ଼। ଗତ 11/2/2023 ଆସାମୀ ସଂଗ୍ରାମ ମଲ୍ଲିକ ତାର ପିତା ପ୍ରେଜେଣ୍ଟ ନରହରି ମଲ୍ଲିକ ତାର 2 ଭାଇ ଏକ ଅବିବାହିତ ସହିତ
mobile phone, ATM card, one Samsung tablet, and some other valuable items from his scooty dicky. My lord, this petitioner is remanded into this case basing on the statement of the co-accused. This petitioner is implicated into this case and subsequently remanded into this case on dated.
How many cases are registered against you?
My lord, there are 6. I have 6 antecedents. Apart from them, I have released on bail on 4 of these cases. I have filed the bail order of those cases, my lord.
Let him to file a description chart, Millet. Let him to file a description.
You file a chart. How many cases are there with affidavit?
Yes, my lord. I have filed.
Where is that?
I have, my lord, page number 4 and 5. In my petition, page number 4.
Statement of
4 and 5.
5.
In my petition, my lord.
Okay, petition. Just see the petition.
Only antecedent reference has been given, but in which case he has been granted bail?
My lord,
He has filed the bail orders also.
Bail orders.
He filed bail orders.
Yes, yes.
Got the bail. All are, I think, similar cases.
Similar case.
My lord, all are remand cases. He was arrested in Khantapada PH case number 236 of 2023.
Except the co-accused statement, do you have anything?
No, CD is not there. This case is a urgent case, urgent by the petitioner Somoto. The CD was not called for.
Because you see, in all the cases, he is on.
I have seen the charge sheet also. This is a remand case, no doubt about it. But he's having criminal understanding.
6 months.
Yes, ma'am. Yes.
Right down.
Yes.
Right down.
My lord,
1 minute.
case is on trial stage, my lord. So there is no chance of absconding or tempering the prosecution.
Okay, right down. Petitioner. He pays for petitioner is accused in FIR number 2. Okay. The perusal of the record indicates that the petitioner is also accused in four other cases, is enumerated in para 6 of the petition. Para 6 of the petition. Then comes for the petitioner.
Lordship indicated four other cases.
Kushbu Panigrai, then comes for the petitioner submits that she has already been granted bail all the cases, and she has also filed the bail orders passed in all other cases in annexure 5. Annexure 5. She further submits that in the instant case, further submits that he was in custody in another case where confession was recorded, and he was involved. He was implicated in the present case. She is in custody since. You are in custody since
17/11/2023. 2023.
2020. Grant the bail, and she will appear before IO. Which police station is that? Contapada police station. No? Contapada police station. Every Sunday for 6 months.
For 6 months, yes.
Okay. You have granted bail, but your client has to appear before, because looking into your antecedent, your client has to appear before the police station every Sunday.
Yes, my lord.
Only to prevent him from involving in further cases. Okay.
I may pardon, just previous item my friends come that informant case.
Yes, 55, no?
My lord.
Yes.
55.
55, yes.
The case under section
Mr.
354.
Rahul,
Yes.
55.
Yes.
Let's see 164 what?
Somebody.
Man, sir. Yes.
Yes. What are the allegations?
ମୁଁ ଛୋଟବେଳୁ ଆଈ ଘର ଗାଁ ସାଙ୍କୁଡାରେ ରହିକି ପାଠ ପଢୁଥିଲି। ସେଠି ମୁଁ ପପୁନ ସ୍ୱାଇଁ ଦିସ୍ ପିଟିସନର ମାଇ ଲର୍ଡ ସାଙ୍ଗେ ସାଙ୍ଗେ ଜଣାଶୁଣା ହେଲା। ସେ
59. My lord, I am committing from Noyad Virtual High Court. Today I am ill and unable to submit regarding the case matter.
Yes, tell me.
Today I am ill and unable to submit the case matter. I want a short adjournment, my lord.
Okay, urgent. He is not well.
My 60.
Mr. Barik.
Barik.
Mr. Ravindranath Barik. Second Councilor that he is not well. Therefore the matter may be. Yes.
60, my lord, section 380, 434 IPC, and allegation that some persons committed theft from train, and they, my lord, alleging that I am the receiver of the stolen properties and receiver of Article 1. And on last occasion, charge sheet submitted. Last occasion, your lordship has granted bail to the those theft my matter was there. Your lordship adjourned today.
Yes, Mr. Maharaj.
And I have, my lord,
311.
No, कोई दूसरी पूरा antecedent show करते दुईटा जोटा कि same day रे गोटिए that cannot be termed as antecedent because arising out of same case. PS case number my lord 128 is there. I mean 128, 127 is one of the antecedent shown on the same day.
Anyway,
and that was been granted bail by the court below. And another case when I am in custody in another case which is after my in custody. So there is no antecedent. My lord, previous case is not there. For that reason, 430. Yes. Theft person have been released on bail by your lordship.
Let's say interested gang. It's the interested gang. I am having the city. The person from outside the state having lots of criminal antecedents. Number one. Number two.
And they have been granted bail.
The vehicle in which the crime has been, the stolen article has been taken away. That vehicle has been seized, and the vehicle owner is the petitioner. Number two. Number three, man, it's a gang. How they are creating the problem, the passengers.
Investigation is complete.
Investigation. I am having the what to that city, but
charge sheet is there on that.
Yes, charge sheet is there. Charge sheet is there. Charge sheet is there. No doubt about it.
And the persons who have been committed, they have been granted bail by your lordship.
There is no criminal antecedent. Having 3 cases similar, and he is the owner of the vehicle, and T numbers of a trolley bag which has been stolen from the passengers of the train that has been seized from the petitioner. He is saying that there is nothing. Trolley bag which has been stolen and it has been identified by the witnesses that these are the trolley which has been stolen and the vehicle has been belongs to the petitioner. These are the materials.
You are a gang. You are operating a
The
gang.
persons who are committing gang, what my learned friend is saying,
So
the persons outsider, they have been granted bail by lordship.
केवल आपनको हेल्प नहीं कि ସେମାନେ एसो करछन इंटरेस्टेड
They have been granted bail by your lordship. That is, and I am alleging that I am receiver of this stolen property that will remain in custody. They are from the outside
So
state and they have
the mistake which I have committed in this case, you want that I should do that?
no.
Okay.
That
Perpetuate
your
the
lordship-
mistake.
on lordship, my friend was there. Your lordship said that since they are 380, they are charge sheet has been submitted. That is your lordship granted bail. And your lordship has done this matter to today.
413
Koile de
life conviction.
receiver.
Receiver who is
Receiver.
receiving the
How
stolen
can
property.
receiver malad 413 re same day gute PS case which antecedent ଦେଇଛନ୍ତି gute 127 PS case number 127 same day FIR. I have been granted bail by the court below. Another antecedent has been shown of 2024 while I am in custody.
What was the offense there?
Say 411 re mu bail payji tolo court
Receiver of a stolen
and on
property.
this case
Similar cases and this matter lordship. Obviously this is very
ultimately I am the
fair.
receiver
But
and
this is-
person who is committing theft your lordship has granted bail.
Those have committed theft, they have granted
Here.
against them is 380, not 413. And against you is 413.
413
Because that is life
And in this case 380 only.
380 only.
And
That is why you are granted bail.
413 is not.
No, I am the receiver of this stolen. They are the committing theft. They have been granted bail.
380 and 300, 413 is.
That is malad. 413, how malad 413? Merely I am
Because your vehicle.
vehicle malad. Maybe malad vehicle. Ultimately, malad I am the receiver of malad. They are committing theft for a person having antecedent. They have been granted bail and same day FIR. How 413 malad?
That is why this
You file an
section of the
affidavit.
provision has been changed.
You file an affidavit.
Yes.
You are an antecedent.
Antecedent malad is.
Listen, you are whatever you are saying antecedent you write and bring these two on record.
Yes.
Bring this on record. Put it on 20 seconds. 20 seconds.
20 seconds.
File these two on affidavit and your antecedents also you say whatever
20,000 for the unit.
20 बहुत सारे मैटर थे
अन्य सिस्टम गत वीक रे
20 और 22 दुई दिन भितर कोन फरक
गत वीक रखिले हो कहले मो रख मंगलवार दिन रखिछि
I understand it, but see, insofar as the other people are concerned, 380. You are charged with 413, where life imprisonment is there. So therefore, you file affidavit. I can get grant bail. Something could come on record. That's what.
I will file record, Malad. I will file.
What is the use? I'll grant bail and they'll go to Supreme Court and get it cancelled. Strengthen your case here.
Your Lordship, I'm replying, Malad. 413, Your Lordship, Malad.
It's all right. There is no point now. 20 seconds, you file affidavit.
I will file. I will comply, Your Lordship. And only thing, Malad, 413, my friend is saying, 413 can be considered as 413 when same day FIR will be registered, can it be considered that it is an antecedent?
That's the reason I'm saying, sir. File the affidavit.
I don't know, perhaps the law.
While explaining your antecedent, you just.
I will be granted bail.
Same day this has happened. So that I can incorporate that and grant.
Same day it is rejection order. That is in the
Write down that.
Yes.
So that in the affidavit.
Note
So that something could be said in the order. Yes.
20 tarikh.
Yes.
20 minutes it will come.
20. 21. 20. That's the problem.
Fresh matters like that. They will be like the heads. And daily on that day, fresh matters will be prepared at least. Filed.
20 second hero. Reach kariban. Today it has crossed 100.
15 दिन पूर्व रहले भी कर देबी मु.
It should be, within the limit of, yes.
61.
The petitioner is a senior journalist. Custody since 6/1/2024.
Surjit Kumar.
Yes.
Hmm.
Yeah, he's in custody since 6/1/2024. He's the editor-in-chief of one e-channel, that is Reporters Today, and also editor-in-chief of Mahabharat. Allegations under section 420, 467, 468, 471 of IPC, a tribal by magistrate offense. This is number one. If you also will kindly see
What is the stage of investigation?
But investigation is going on, lordship may some time may be given so that I can take instruction regarding the completion of investigation in a certain period. So the IO is out of station, he is in Bihar. So can I pray for some time to?
Next week?
Yes.
19th. 19th. 19.
19. 19.
62. Yes. Yes, diary.
So only I pray since it has been adjourned to 19th, but last occasion also he undertake, but this today it will be disposed of. Since my friend has some difficulties, at least he should not ask for time.
Maharaja seeks further 1 week to time to get instruction regarding the stage of.
But ये case मात्र गोटे थर आस्तला, with all respect to my senior, ये मात्र गोटे थर आस्तला, it should not be. With a folded hand, my lord, I'm saying, it should not. I have undertaken to take instruction. This should not be.
No, I am just saying that last
Only
time.
one date, first date.
Last time it is simply at the end. I am just saying, Mr. Maharaja.
Exactly.
I was shouting. The court at least should maintain the decorum of the court. Don't shout.
No, I am.
Don't shout.
Undertaking, undertaking koi paribe.
Investigation.
You cannot say I have undertaken.
What I will say, what I will not say. The
All right.
court will decide. You can decide.
All right.
Say me. I have not taken undertaking. Then I am summing before the court.
See, Mr. Maharaj, don't spoil your mood because there are 100
I
matters.
don't understand why it is spoiling.
It will have an impact in other cases.
No simple kaichi je gote iota.
Cool down. Cool down.
ମୁଁ ତ ସେଇ କଥା କହିଲି ଯେ last date ଆସୁ, last date time ନେଇଥିଲ, ପୁଣି ଥରେ ଆସୁ।
Last time ठीक जे undertaking କହୁଛନ୍ତି ମୁଁ undertaking କରିଥିଲି।
It's all right.
Last date ରେ କହିଥିଲା ଆଜି dispose of
All right, Mr. Pradhan, no further.
What my senior has used undertaking. That is why I became.
Okay. Don't spoil the mood of the prosecutor. It has an impact in others. Yes. Okay.
376 minutes CD required.
CD.
Next week may come.
CD. See, the same thing will happen. How much he can handle. He has to call and the investigators has to cooperate with him.
Like CDB call for first time CD call for hoche today.
Yes. 63.
Lord, last occurrence, lordship heard this matter, and I am on a technicality that I have given one judgment of Amarnath, and that condition also extended to me also. I am claiming that condition what was imposed by in Amarnath case, that is also extended to me, my lord. That is paragraph 5 of the Amarnath case, last occurrence I have given the judgment, my lord.
Where is that? We have the file. Bail matter, we don't have file. That's the problem. Where is Amarnath Swami?
Yes, my lord, I have given that.
File it, because in bail matter we don't have any file. Everything is here inside.
In fact, let me paraphrase what my friend want to say. There are two bail applications in 63 arising out of one incident.
You are in one.
I am in one. Now it is the allegation that some contraband was seized from his possession a year after I am arrested. We both are relative. There is no dispute at all. Now,
what is the contraband? Ganja. How much?
104 kg, my lord.
104 kg.
Okay.
When it was listed before Minor Justice Rother, it was brought to notice of the Honorable Court by my friend, that in view of the length of incarnation, I am entitled to get the benefit of the decision rendered that Amarnath, that is. So far as factual matrix is concerned, your lordship has already said on last occasion, also my friend Mr. Maharaj also said that the consensus position is not there. But bearing one thing, there is a report on record. M or something.
Flag K.
Looking at this, your lordship, at the earliest was of the view that the court has started functioning. In fact, it is not really reality. Court has not started functioning. That is what referred in Amarnath case. That the concerned court is not functioning. There is a long.
Yes, is it functioning? Because this the report which was read out by this was very vague kind of report. Vague kind of
That report your lordship has received, perhaps I.
Yes.
No, that is flag K.
That
That is flag K, my lord, and that is
flag K.
That report is there, your lordship. May kindly see that.
Flag came in the second, you know, 307 में flag K.
Oh, 307.
Flag K.
That was called for. Yes, my lord.
See, this report is seems to be vague due to non-availability of the presiding officer since 1/6/2023.
My lord.
After retirement of the previous presiding officer.
My lord.
Hearing on the charge could not be taken up.
My lord.
Now the case record stands posted to 5/4/2024 for hearing on charge.
My lord, that was observed in
whether the officer has joined or not, nothing is coming home.
Not joined, my lord.
Your lordship may have a glance. Whose report is this? In which court it is pending?
This
I
is
think
additional district judge.
Yes, that was pending.
But who has given the report? I think it is by
additional decision.
Additional court को जाए.
In charge.
Yes, my lord.
In charge decision.
In charge. That means the posting court is not functioning. Posting court is not functioning.
No, the order is very vague. Right.
And period of detention is also.
Right on. The additional district and sessions judge in charge, Jaipur, has submitted a report dated 12 February 2024, which indicates that the presiding officer of what? Presiding officer conducting the trial.
Yes, my lord. Session about the matter.
Case?
This case, my lord.
That is. Tell me that.
Jaipur Sadar PS case number 370.
TR case number.
TR case number 74 of
74. Yes, my lord.
Uh, 74 of 2022.
Within bracket A. Within bracket A.
Within bracket A. Within bracket A. TR case number 74 of 2022 bracket A. Was not available until 1/6/2023. Although the report indicates that the matter is fixed for framing of charges, for hearing on framing of charges on 5/4/2024, but it is not clear as to whether the presiding officer has
Year number is
47, 74, 47.
That is why.
No. My case is 7.
Case is separate and this case is separate.
The 74 second matter I am talking about. I am reading.
Sir, BLPL number 307. 307.
Hmm.
Then 307 you have the office right.
Yes.
307 I am writing only.
Yes.
Gotre Pulale did the same name.
See that. See the problem.
Has already joined after the retirement of the previous presiding officer.
Yes.
Let a press report be called for from the district and sessions at Jaipur. Leaves the matter on. Leaves the matter on 27. Report, let the report.
Yes.
In se thatra karibo same report ta.
Arotare TR case ta 47A.
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 47A kar do. After. Yes.
64.
The offense is 394 million. It is charge sheeted by the IU on the basis of the confidence statement of the principal accused, my lord, who was confessed that the petitioner was along with them. And only basic upon that confidence statement, the petition has been implicated, my lord. Except for confidence, there is no other material, no tape, and no recovery.
Yes, Mr. Maharaj.
Yes, sir.
But is there anything except the confessional statement?
Exactly, madam. While collecting loan amount of the informant, he was holding 2,13,700. 3% came and taken away the entire amount. The no doubt Maldi remanded this case and he's having 9 criminal cases similar nature.
That's true, but in this case, only confession before the police is implicated now. There is no other material.
Yes. Confession
And
before
the person who was confessed will be released on bail by the non-court bill. I'll see the order, my lord.
Yes.
Except confession, nothing.
Except confession, nothing. Below confession made in connection with the PS case number 57 of 2022.
He was taken into custody.
In industrial PS case number 127 of 2022.
No. He was in custody in which case?
সেটা হচ্ছে Kasinda PS case number.
Kasinda PS case number, my lord.
57 of 2022.
Yes, my lord.
First, the petitioner is accused in annexure level, annexure 1 level. It is in FIR. Ulta Sida annexure 1. The allegation against the next, while the petitioner was in custody in connection with the
Kisinda PS case number 57.
Case number
57, dated 28/6/2022 under 395 of the IPC.
Clearly,
Kisinda PS case number 56.
57.
So 57 dated 28/6/2022.
57/22. 22.
Where he has
57.
Some IT jealous that he has confessed regarding his involvement in the present FIR. The allegation against allegation in the FIR is that it is a FIR. Yes. Mr. Maharaja appearing for the state submits that although except the confessional statement, no other material has come on record as yet. However, the petitioner is involved in as many as 9 cases.
Similar.
Therefore, in the event the petitioner is given the concession of bail, strict conditions should be imposed against him. 6 months.
Yes.
6 months every Saturday, every Sunday. Yes. Yeah.
Maybe.
Huh?
65.
May please, sir.
Offense is for the informant one.
Sir, offense is 427 and charge sheet has been filed. And last occasion, the court directed to implement a party and opposite party appeared. And your honor also advised me to present before this court with a draft of 5 lakhs. So I have already, sir, I have already prepared the draft and also assured
The amount is 47,70,000. And
I'm not recording an acquittal.
Sir, this is the draft I have prepared according to the court.
Your lordship may fix some installment.
Why don't you pay him and finish it up? You have taken the money.
Right, sir. Sir, ବାପାଙ୍କର ଦେହ ବହୁତ ଖରାପ ଅଛି sir ଦେଇଦେବି sir. Religion.
To begin with, Mr. Vishwal, to begin with, you take it and we will bound him so that I'll record his undertaking also.
Yes.
He would make all endeavor to pay the amount. So that at least money.
Time stipulation.
Yes, sir.
I'll write.
Failing which?
Failing which, then the reconsideration of bail.
FIR.
What is the allegation against you?
Sir, within 2 years, sir.
Wait, what is the allegation?
420.
1 minute. What is the allegation?
Allegation 420 that he
what is the allegation?
assured, sir, provide a house. Assured to provide a house.
House
And you are the bidder.
It's a real estate business.
Building. He has committed to give me, provide that house. He failed to provide me.
And
47,70,000 he has taken from me. And
he doesn't have the property also with him.
Sir, property is there, but due to some civil disputes, sir, I
could not be delivered the property.
You've taken 47, you are leaving him with
He
land.
had an agreement with me and with the some checks, 4 number of checks. Each carries 11 lakh 92,050.
This is a multi-story building. Wanted to.
No, sir, multi-story,
But
single.
Why don't you give the land to him?
Sir, actually, my elder brother and me, while my elder brother was a brain stroke, I was executed this agreement. After death of my elder brother, sir, my the wife of the elder brother did not agree to sell the property, so that I will ready to return the amount, but a stipulated time.
Land is with you.
Land is belongs to me and my brother.
Give the part of the land and finish.
Sir, it is a homestead.
3-story building in
Sir, I will return the money, but some time is needed. But now I am giving the 5 lakhs.
Then you will be started cheating other people.
Sir, already RCD already filed. And trial.
There is an antecedent also. The honorable court, court below has found that.
What I suggest, let him accept the 5 lakhs, and he may be granted bail. In period of 6 months, he has to pay another 30 lakhs.
That.
At least you arrange. Right.
Sir, within 1 year, sir.
Petitioner is an accused in such.
Sir, 1 year time.
1 minute. Session chat. The allegation against the petitioner is he has the informant. He has entered into an agreement on 26 February 2020 with the informant and has taken 47 lakhs. 47 lakhs 70,000.
70,000.
Towards with a promise to give him a building, huh?
Yes.
Sell a house.
Huh?
Sell a house.
Sell a house.
Sell a house, 3-story building in Acharya Vihar, Bhubaneswar.
It is an admitted fact that the petitioner has indeed taken the entire money. However, he could not
neither provide
either return the money or could execute a sale deed in favor of the informant.
Yes.
Insofar as the promised property is concerned. So the petitioner is in custody since
5/1/2024.
5/1/2024. Full stop. The
And charge sheet filed.
petitioner has brought a draft of rupees 5 lakh in the name of informant by his own volition.
Yes.
By his own volition, and on instruction, the learned counsel for the petitioner promised that the entire money he has taken from the informant shall be made good within a period of 6 months.
Sir, 1 year.
1 minute extension mago, like in 6 months. 6 months hence, taking the undertaking on record. The petitioner seeks indulgence of this court. Having regard to the fact that the petitioner on his own volition has started offering to pay back the money to the informant, I am of the considered view that the petitioner is entitled to bail, subject to condition that he satisfy the condition, satisfy the undertaking given to this court. The condition is always there.
Yes.
Compliance of the last one, non-compliance of the condition of the bail shall entail
recorded that the advocate received.
And
the advocate received.
Mr. Vishwal appearing for the informant, although except the draft, except the draft with protest, with the protest, and without with the protest and without prejudice to the right and contention of the right and contention of the informant. Have you filed a civil suit for recovery?
Not yet.
When the agreement was there?
That is, the agreement was 26/2/2024.
So that
sorry, 2020.
See, the limitation has gone.
Yes.
But since this, he has given this draft now, and the 6 month I have given, your limitation extend till the 6 month.
Oh, like.
Now you can file a suit.
Yes.
Because from the date of decline, and he has promised now he has extended your limit.
Sir,
You
I will pay the.
Better you can file suit. You may not.
Sir, I will pay the 50%, but 50%.
Whatever, but at least his limitation had already gone.
Sir, maybe recorded the advocate for the petitioner received the draft.
Yes, I have written. And since he gets the limitation, you file, at least use this money for court fee. But can file a suit, isn't it? That's the best way.
Sir, the please.
On instruction, your everything is recorded.
ମୁଁ ତାକୁ already given advice ନାଇଁ direct list.
Yes. May I please, my lord? My lord, alleged offences under section 20B2C of NDPS Act. Petitioner is in custody since 4/7/23. My lord, as per FIR, my lord, and 3/7/23 SI of RPF Puri nabbed 2 persons from the railway station, and from them they seized 9 kilo 121 grams of ganja from my present petitioner, and and another accused person 29 kilo of ganjas, my lord. My lord, that is also mentioned in FIR page 9, my lord.
From you, how much?
9 kilogram 121 gram.
Yes, Mr. Maharaj.
ସେଇଟା ତ ମୁଁ କୋଉଠି ଦେଖିନି ସେ total 38
FIR ଅଛି, my lord, page 9, my lord.
this 9 ଅଛି
Just see, page 9. You are Mr.
Narayan, my lord.
ଏମିତି କେମିତି ହେଇପାରିବ ମାନେ
Dita bag route,
the
dita.
circumstances is it's a platform. 3 bags were laying. 2 persons were standing beside the bag.
Yes.
How can it be segregated that he was holding a one bag of see?
That is
3 bags
written.
were laying on the platform of the railway station. And 2 persons were standing.
Who all are the independent witnesses?
Yes.
My lord, if your lordship
Yeah.
turn to,
How will you relate that bag to them?
Because they were holding all, they were,
Where they holding or it is lying?
it is
They were
lying,
standing
they were
beside.
sitting.
They were standing beside.
No, they were sitting.
Hmm.
When they tried to fled away, they were nabbed by the
Where are see?
police.
That, see that.
ସେଇଟା ଟିକେ
The notice what court was that 2 male young persons were carrying one green come black color bag in the right hand side and another 2 bags. So that is one is maroon come black bag on his right hand and his blue come bag in the bag.
segregated ହେଇଥିବ ତାହେଲେ
Looking.
secretary FIR mentioned ଅଛି.
They were both waiting at platform 1. You are holding it, not that it's lying. Extremely good and side of the Puri railway station is very
ନିଅ ମୋଠୁ ଦେଖିଦିଅ ଦେଖିଦିଅ
suspicious. They detailed them.
ନାଇଁ ନାଇଁ
Good every way you are. Go on. Puri railway station. Code number of packet for very long.
I am having the seizure list, one seizure, all have given their signature. Net weight is 29 kg, 685 gram.
My lord, but from the present petitioner bag, that is 9 kilograms, 121 gram.
Where is that?
That is on page 9 FIR, my lord.
Page 9.
9 FIR. May I read, my lord, that
Yes.
portion?
Which portion?
First information contents, my lord. The top from the bottom to my lord 8 line 2. The ganja along green come black color bag and white color poly bag of Narayan Singh, gross weight 10 kilo 600 grams.
Where in page 9, huh?
Page 9. Net weight of the white poly bag 1 kilogram and 479 gram. The ganja along blue come black color air bag, maroon come black color bag and a white color poly bag of Budra Mali, gross weight 32 kilogram from 300 grams. Net weight of ganja is 29 kilogram and 685 grams. That is mentioned, my lord.
Segregate किसको रहा है? It's a one
Even if your lordship may turn to page 13, my lord.
Weight 10 kilo 600 gram with the help of
से जो बैग गुड़ा का थोड़ा इतना से बैग गुड़ा का तार कलर अनुसार तक वो segregate करा होता है. That's not the से बैग का स्टार.
Another box 2, one blue from red, I'm not able to get anything where you were reading.
My lord. From top to 8 line.
What you have filed the charge sheet?
Yes, charge sheet submitted.
What is
They
this?
are outside there. They 2 are outside. 2 accused persons, they are outside. Man of West Bengal. Charge sheet has been filed on 30/12/2023. One seizure list. Total weight is 38 kg. 806 gram.
This is that way that page 9 I am not able to get where, how.
My lord, the first information contains, my lord.
I understand it. Which line?
From top to 8th line, my lord.
Okay, the ganja along with the blue bag color hair bag, maroon black bag and white color poly bag, Budram Mali. Wait, so ganja along with the green and the white color poly bag of Naran Singh.
Yes,
Gross
ma'am.
weight is 10 gram, 10 kg, 600 gram.
Yes, my lord.
And net weight is 9.
9 kilograms.
Yes, Mr. What do you say?
We have one step.
One seizure list.
Once.
So, showing that recovery is 9 kilo 121 only.
No,
So for a G
totally
concerned. No, but he, as far as he is concerned, it is recovered.
But we have not segregated the quantity.
Now, how do you think, what conscious position, how much you consider?
Because on same place.
But
same-
it is recovered because they were traveling together.
Yes.
They are holding two different bags. The conscious position, insofar as Narayan Singh is concerned, how much you will consider? Because you have only said.
I mean, accepting you also may consider. Because outsider you also may that condition.
Yes, right on. The allegation against the petitioner is accused and so on. The allegation against the petitioner is that he along with one Budhiram Mali were apprehended in the platform of Puri railway station. Insofar as the present petitioner is concerned, a bag was recovered from him, which contained 9 kg and 221 grams of
121.
121 grams of ganja from the said way. Said way. Said way. But however, insofar as Budhiram Mali is concerned, the bag he was carrying contained about 32 kg 300 grams of ganja. 29 kgs and 685 gram of ganja. Okay, in Budhiram. Budhiram. So therefore, in so far as the present petitioner is concerned, it could be the conscious position of 9 kg 121 gram of ganja is confiscated. Is seized from him. Seized from him. Okay. And outsider.
Say
conditions outside. Okay.
Obliged, ma'am.
7. 68. 69. 69.
May I please?
62.
16. May I please? Offense is 323, 307, 34 of IPC. The accused is in custody 4 AK 24. And charge sheet already filed 28 1 24.
307.
Yes, sir.
Yes.
Injury.
2 is simple and 1 is grievous.
3 grievous injuries. 3 grievous injuries. Custody 4/1/2024. Investigation on having 1 criminal antecedent.
Charge sheet. Okay. Let me charge it now.
Charge sheet filed, sir.
Now, in the meantime, charge sheet.
Investigation is on.
Now, in the meantime, charge sheet.
Sir, I have filed the charge sheet.
After the filing of this bill.
What are the allegations? Where is the medical?
Yes. I am having the medical report and along with the statement of the injured.
Yes.
The injured is Saurabh Parida. He has stated implicating ମୁଁ ବଜରଙ୍ଗ ଶାସନ ସାମଗ୍ରୀ କିଣିବାକୁ ଯାଇଥିଲି ସେହି ସମୟରେ ଆମ ଗାଁର ମନୋଜ ଜେନା ପିତା ମଙ୍ଗଳ ଜେନା ଦିସ୍ ପିଟିସନର ତାଙ୍କ ସାଙ୍ଗରେ କାମ କରୁଥିବା ସୋନୁ ନାୟକ ପିତା ଅରୁଣ ନାୟକ ମାନେ ପୂର୍ବ ଶତ୍ରୁତା କେନ୍ଦ୍ର କରି ମତେ ଜୀବନ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ଲୁହା ରଡ୍ ଓ ପାଇପ୍ ସାହାଯ୍ୟରେ ମାରାତ୍ମକ ଆକ୍ରମଣ କଲେ ମୋର ମୁଣ୍ଡରେ ଡାହାଣ ଗୋଡ ଡାହାଣ ହାତ ଓ ଅନ୍ୟ ସ୍ଥାନରେ ଗଭୀର ଆଘାତ ହୋଇଛି ମୋର ସ୍ତ୍ରୀ ମତେ ଏମ୍ସ ହସ୍ପିଟାଲ ଚିକିତ୍ସା ପାଇଁ ଆଣିଥିଲେ ଏହି ମୋର ବୟାନ ଅଟେ
Chatta grievous ଅଛି.
He's in
two simple 1 2 3 4 5 6 out of 6 injury 4 are grievous. Too simple.
Sir, in rejection.
Yes. Which part of the body just see?
In rejection, 3 grievous, which includes 2 laceration.
No, you just see the page what is called You have filed this.
Yes.
Eh,
Last of the
Akhil
chapter.
Bharatiya Ayurvedic Vigyan, AIIMS. Parida, Saurabh Parida, na?
Saurabh Parida.
Saurabh Parida.
Sir.
Medical report, just see,
Yes.
there is a table, detail of injury.
Yes.
And in the last, if you see simple, grievous.
Yes.
No, there are 5 injuries.
Five.
Not 5 injury, 3 are grievous.
Sir, he is well and discharged from the hospital and residing now.
Fractured, just see which part of the body? Just see. Grievous injuries.
Scalp movement,
Oh,
laceration. The fourth injury, loss is column number 4.
dangerous.
Scalp injury, laceration. And the third is occipital.
First week. Which दिन bro? First week of it. Okay.
The last of
Keep it there. Second, third. Huh?
the last week of this month.
No,
Even
last
Sestadu
week,
Rao, sir.
छुट्टी आओ. First week last. Head injury.
Sir, he is well and
Grievous injury.
sir, he discharged at OA. He is
That may be. He is lucky that he survived. Lucky that he survived. Such serious injury. Fractured. First week जाए ना तब दे दो.
again.
इस दिन करो. Yes.
My pleasure, Lordship. Out of same affair, another 2 bail application pending before this court.
When those.
My lord, the last occasion or my lord was directed, but not till, not
Yes.
today is coming. BLPL number 256 of 24 and another BLPL 749 of 24.
What are the offenses?
My lord, 21
40
NDPS.
kg, 305 gram ganja.
Okay. 40 kilo. 40 kilo. सब जगह लगा दी. All the 3 accused, huh?
Well, 3 accused. Present accused is the escorting, that is no possession, exclusive possession.
We will see.
Right.
Next week. Okay.
Madam.
Item 70.
May I please, your lordship. My lord, I am open to VC, my lord.
Yes.
My lord, the petitioner is custody since 26/7/2023, my lord. Initially, FIR was lodged against 363 of IPC, my lord. In the meantime, charge sheet has been filed on 31/10/2023, my lord, under section 363, 366.
1 minute. Notice is required to be issued.
My,
Give a extra
my
copy.
lord,
Yes.
my lord, I have filed the notice, my lord. Already I have filed the requisite, my lord, on 4/3/2024, my lord.
Fourth, acha.
अच्छा, requisite you have filed, huh? Issue notice, yes.
সেটা outing বলে।
You service.
My lord,
Service, no? Physical class.
কিছু লিখাই। এটা তো 17 আছে।
77. Yeah, notice has gone, but no reply. Wait, we'll see.
my lord, may kindly have a glance to annexure 2, my lord, 164 of the statement of the victim, my lord.
But
Page
let
10,
us
my lord.
see, somebody may appear. Therefore, I'm saying, I'll call it once again after.
My lord, my lord, my lord, may I submit, my lord?
Hmm.
In the court below, my lord, notice was issued to the informant. In the meantime, she has appeared and she has stated that she has no objection if the accused is released on bail, my lord.
Where is that?
My lord, may kindly have a glance to it.
Yes.
Page 12, my lord, Annex 3.
Yes. Yes.
Yes, yes. Last para.
Victim informed. I
Yes.
appeared before the court.
The word started from the victim and informant appeared before this court.
What is 164?
164, that is there.
My lord, 164, my lord.
Page
Annex
10.
2, page 10, my lord.
Yes, yes. Just see what is what are the allegations. এই বছর
ମେ 13 ତାରିଖ କି ମୁଁ ଘରେ ନ ଜଣେଇ ମୋ ସାଙ୍ଗ ସାୟା ଆଉ ପୁଷ୍ପା ମାନଙ୍କ ସହିତ ଚେନ୍ନାଇ ଯାଇଥିଲି। ଆମେ ଆଗେ ଭୁବନେଶ୍ୱର ଯାଇଥିଲୁ, ସେଠୁ ଟ୍ରେନରେ ବିଶାଖାପାଟଣା ଆଉ ବିଶାଖାପାଟଣାରୁ ଟ୍ରେନ ଚେନ୍ନାଇ ଯାଇଥିଲୁ। ସେଠି ମୁଁ ସାୟା ମାୟା ନାୟକ ଆଉ ପୁଷ୍ପା ନାୟକଙ୍କ ରୁମରେ ରହିଲି। ସେମାନେ ସେଠି ବିଗ୍ ବଜାର ସପିଂ ମଲରେ କାମ କରୁଥିଲେ। ମୋର ସାଙ୍ଗ ଅରୁଣ ନାୟକ ବି ସେଠି କାମ କରୁଥିଲା। ମୋର ତାଙ୍କ ସାଙ୍ଗେ ଆଗରୁ ଫୋନରେ କଥାବାର୍ତ୍ତା ଥିଲା। ସେ ମତେ ପଚାରିଲା ଘରୁ କାହିଁକି ପଳେଇ ଆସିଛୁ? ମୁଁ କହିଲି ରାଗିକି ପଳେଇ ଆସିଛି। ସେ କହିଲେ ତୁ ମୋ ପାଖକୁ ଆସ, ମୁଁ ଘରେ ଛାଡ଼ିଦେବି। ମୁଁ ଅରୁଣଙ୍କ ପାଖରେ କିଛି ଦିନ ରହିଲି, ତାପରେ ସେ ଆଣିକି ମତେ ଭୁବନେଶ୍ୱର ଛାଡ଼ିଲେ। ମୋର ଅରୁଣ ନାୟକଙ୍କ ସାଙ୍ଗ ଭଲ ପାଇବା ସମ୍ପର୍କ ଥିଲା। ମତେ ଅରୁଣ ରେପ୍ କରିନାହାନ୍ତି। ଏହା ମୋର
Right. Petition is accused in so and so. After investigation, charge sheet has already been filed. On 1/3/2024, notice was issued to the opposite party. Notice was issued to the victim. However, nobody appeared. When the matter was taken up before the court below, at the bail stage, the victim appeared and stated that she has no objection if the bail is granted to the accused. Bail is granted, which is reflecting in the order dated. Where is the date of this order? Order dated 6/1/2024, passed by the additional district judge and special court under POCSO Act. Perusal of 164 statement. 164 statement recorded under 164 CRPG indicates that the petitioner on his own volition had gone to Chennai, where the accused gone to Chennai and stayed with him. The petitioner was staying with the other staying with K. Sarika K. Kitana. Petitioner was Puspa Naik. Maya. Yes. Petitioner has been staying with one Maya and Puspa Naik. One Maya Naik and Puspa Naik, who happens to be friend of the victim. Friend of the victim. She started staying with her friends and developed relationships with the petitioner. She has also stated in 164, stated in her statement that the accused has not committed any sexual assault on her. Yes. Taking into consideration granted. Okay.
Deeply obliged.
Yes.
71. Next. This case may be taken up along with the BLPL number.
Write down.
1013.
101.
1013 of 2024.
24. Okay.
72.
Well, offense under section 294, 427, 506, 140.
Yes, allegation, tell me.
Well, he's in custody since 21/2024.
Allegation?
Allegation that my lord,
no allegation. No allegation.
No, my lord.
Tell me what are the allegations. You start reading now. Urgent. Let him prepare and come. Urgent. Yes.
147, 148, 440.
What is the allegation I am asking? You are reading the section.
You cannot read the vernacular.
You
cannot read the vernacular.
Okay.
Having difficulty.
Why don't you translate and read and come? I'll pass it over. Read it, pass it over. Prepare and come. After 2 o'clock, I'll take.
Yes, ma'am.
Prepare and come at 2 o'clock.
I'm ready.
Yeah. Next.
73.
My lord.
Sorry?
354A and 506 and 10 of the
354.
The charge sheet already filed, my lord, and the custody since 15/1/2000.
Investigation over.
My lord.
But I don't have charge sheet. Yes, madam. Yes.
You have not filed anything.
23/2/2024 charge sheet filed.
23
February 2024.
What is
160 for your lordship may kindly see. I am reading blood 164 statement. But the Aji mo ता 3/1/2024 दिन आपण निकट रे बयान देखु जे ता 28/12/2023 रिक दिन मु घर बाहर थिबा कुकुर मानको भात खाइबा नै देउतिली सेही समय रे
see, although the FIR was registered against the petitioner under section FIR annexure order. However, after the petitioner, one petitioner, two petitioner.
Two petitioners.
The petitioners were on bail in the state FIR. However, after investigation, charge sheet has been filed.
Adding offense 307.
Offense under section 307 IPC. Therefore, the petitioners seek indulgence up to this court, indulgence of this court for seeking, inter alia seeking for quashing of the entire charge sheet on the apprehension that once he surrenders, he may be taken into custody. Full stop. I'm not inclined to interfere in the present case. However, the petitioner is at liberty to seek remedy under law by relying upon the judgment of court.
Okay. Item 2.
May it please your lordship. Your lordship, the petitioner has approached this honorable court for quashing of the cognizance order dated 8/5/2018, and that is in Annexure 2, page 20. And the trial court took cognizance under section 409 of the IPC against the petitioner. The factual matrix of the case is that the petitioner, being the director of one Ganpati Paraboiling India Limited, was to deliver rice of around 44,911 quintal, but he could deliver only 36,395 quintal because of the loss of crops. So my humble submission is that the entire transaction was a financial one and was civil in nature, and no offense under section 409 was made out against the petitioner. But in spite of that, the FIR was lodged against him, and during the time of bail,
Appearing for opposite party number 2 and 3.
Odisha civil.
Notice may issue to them, my lord. As because they will appear, my lord, they can.
Will settle it.
My lord, entire transaction.
Director, my friend Maharaj.
Yes.
Take instruction, but the IO pray for some time, my lord. Now that we given, and also in the meantime, notice.
For the last 2 occasions, my lord, they are trying to get time, and I have annexed all the documents.
They are trying to help you.
I have
Cognizance order. Why should I interfere?
No, my lords, I have paid the entire amount. Apart
Those things are defense. You can argue at the charge stage, and you have a defense.
Yes.
If they are seeking time, only to help you, so that if the other side comes, then we will settle out and pass the entire property. That's the whole idea. So issue notice to the opposite party, number 2 and 3.
Interim stay may be granted, my lord.
What is the case? Let us see.
Actually, the entire case is that only
show me the
yes, my lords. Yes, my
allegation.
lords. Yes, my lord. My lord, may kindly see annexure
Page 70.
annexure 4, page 24.
24.
Yes, my lords. The first the charge sheet, the FIR is in page 16 under section 409.
Right, 17. You read 17.
Page, yes, my lords.
FIR regarding misappropriation.
Yes,
PD.
the Odisha State Civil Supplies Corporation, a state government agency, has been procuring paddy under decentralized procurement scheme of Government of India since Kharif marketing season KMS 2003-4. The main objectives of the scheme as per para 4 of the Food and Procurement Policy for KMS 15-16 are to procure paddy directly from farmers on payment of minimum support price, to mill the paddy into rice, and to distribute rice among the beneficiaries under the public distribution system, National
Para
Food
5,
Security.
come to para 5.
Para 5 is that after procurement of paddy from farmers of different districts through primary agriculture cooperative societies, women self-help groups, primary agriculture cooperative societies, women Sorry, my lords. And Pani Panchayat, the same is delivered to the millers
You
of
are
the
Pankaj
district.
Agarwal.
Yes, my lords.
Pankaj Agarwal, so being.
Seven,
that-
para
That is
seven.
para six,
Seven.
para six, he is participated in the procurement operation.
Para seven.
Per the operational guidelines and participation in the procurement operations. Accordingly,
And he has made a security deposit of 72 lakhs also, my lords. And thereafter, the remaining 1 crore 22 lakhs, 29,133. That amount was already been paid as per the direction of this honorable court while granting bail to pay the entire amount within 6 months.
You paid.
Yes, my lords. Within 4 months, we have paid.
In fact, the due amount 5 crores 72 lakhs, my lord. Or that is
No, no, they
Cost of quintal so and so paddy is 1 crore
my lords.
94.
Yes, and
so-
74 lakhs
and
was the.
Cost of the gunny bag is so and so. Aggregating the total misappropriation amount is 1 crore 90. Just see, para 7.
Yes, my lord. 94, which the miller is liable to pay
Is liable to pay the state supply so and so.
after recovery
And
of
after
72 lakhs.
Towards the security deposit and miller so and so. He has paid it.
Yes, my lords. 72 2
That
lakhs.
interest of 12%.
Yes, your lordship.
2%. You have paid this.
Yes, I have paid that. And thereafter, the remaining 1 crore to 22 lakhs, which was remaining, as per the direction of this honorable court, to pay the entire amount within 6 months while granting
Shall I
bail.
record your statement?
Yes, your lordship. The bail was granted on 15/9/2017.
These two stones. Okay, yeah. Mr. Ragada, it is noticed. And charge sheet has been filed?
Yes, your lordship. And in the charge sheet itself, they have accepted that the entire amount is paid.
Where is that?
Yes, my lord, I am submitting. In para 16, subsection 21. Fine.
Huh?
In para 16, 21.
21. The
And thereafter in 22.
right now. The allegation of the allegation against the petitioner is he has misappropriated 1 crore 1 comma 94 comma 39 comma 570 rupees so and so, huh? And the said amount is recoverable from the accused, the petitioner. The investigation is completed and the charge sheet has been filed. And in the charge sheet, the following government has been made. 16.221.
Mana 21 and 22 also. It is clearly mentioned that the entire amount has been paid.
Taking into consideration the aforementioned facts, the further proceeding in so and so, further proceeding in GRK pending in the court of SDJM Bhadrak in
Yes, Lord.
GR case number 1503
Of 2017.
is there. Let them come with
Yes, your lordship. There is a demand of another 5 lakhs that was also paid, and I have annexed all those.
that you have annexed.
Yes, my lords.
But 12% interest also you have to pay.
No, everything has been paid, including the interest. Everything they under only the and they requested.
Why
my
don't you
petition-
approach the concerned authority seeking quashing up for the entire proceeding? Because you have already paid. It is recovered.
Yes, your lordship, and I have been requested by my letter to withdraw all the cases because the entire amount has
You have
been
already paid.
Yes, your lordship, the DD, yeah, DD number, everything is annexed.
Then you persuade them. Let them come. We'll see. We'll
My lords.
watch it.
My lords.
Yes.
Highly obliged, my lords.
3.
Item 3.
Yes.
Item 4.
Lord, you have forwarded 24/1/2024. The complainant, who is the opposite party here, he has not produced the witnesses, so that I could not able to examine. So let it
No
come.
agency is involved in the present and furthermore, The position
Because
of-
what happened in this, I disputed the signature. I filed a petition to send the expert but the honorable court says that after examination it will be so after 2 weeks it will be taken out so that I will produce the deposition copy of the evidence. So that is the because after examination because at that time 311
What happened to 313 statement?
Hello?
330 statement is recorded.
No, because of after this, I filed the recall petition. It is allowed, but the opposite party is not produced the witnesses. For that is the reason because at that time it was posted for 311 petition. So now it is for a cross examination for complainant and other witnesses.
What do you want?
So we want only after 2 weeks. I will produce the deposition copy for that.
You want an adjournment? Release it after 2 weeks.
Yes, yes.
After 2 weeks, anytime. Yes. Item 5.
May I please. My lord, the order of cognizance is under challenge and the cognizance has been taken under section 138 of NI Act. Your lordship may get it at annex page 18, annexure 2.
Yes.
Prior to that, your lordship have glanced the next page. That is page 19. The check itself is available if your lordship have a glance.
19.
Yes.
Yes.
The materials alteration in the instruments is clearly visible to the naked eye. 1 lakh was written. How it has been manipulated, your lordship have a glance. Despite that,
1 lakh.
1 lakh, my lord, they has made it 10 lakh.
But figure is 1 lakh only, or 10 is added.
One has been added. It was very much available before the law and trial court. Despite that, my lord, without applying mind, my lord.
Where is the reply to the legal notice?
Legal notice has not been served. It is their admitted case.
Where is that? Complaint case. Complaint, just see complaint. Where is the admitted case? Legal notice, how do you say admit? Just see para 4 of the complaint.
Para 4 of the
Receiving the memo of so
that after receiving the memo of the bank regarding the return of
legal
check.
notice dated 7/4/2023.
Yes.
Through his advocate 132. And legal notice.
Calling upon him to pay the amount by the check.
So why do you say that it is admitted that they have not given? They have given. Why are you making?
They given, but it has not been solved. They have.
That's a different
yes,
story.
yes.
But
No,
they have
legal
given-
notice has been that is
where the notice is sent to the accused through the registered post, AD,
on his
and,
residential address.
in the
Yes.
residential address, and on a also was a holiday of the postal
Some overwriting is there, and knowing the
Knowing fully-
accused has refused to receive the said legal notice as
and
revealed
revealed
from the endorsement given by the postal authority.
these are tribal of things.
It was
So
notice
here-
was issued, but
notice
it was not
issued,
served.
It was served or not served, that is again.
No, it was not served. Yes, my contention is it was not served, but your lordship have a glance. The check itself.
I'll simply issue notice.
Now, unless stay is granted, but now
You show me in the reply to the statutory notice. You have said that it is manipulated. I have not issued.
the notice I have not received.
It was sent to you to postal affair. He is very
Well,
specifically aware.
let him come, my lord.
Let him come, that form.
Let him come until then, man, stay. But unless it is stayed, my lord, the Lord trial court is insisting for hearing. That is the whole problem. Otherwise, the lordship may fix
Insisting
it.
for hearing only. Nothing great is happening.
No, if my lord, the evidence will start, my lord.
The problem is in 138, if the notice is issued, if you don't reply.
Yes,
after
that the
receiving,
reply has to be given.
then
Yes,
the
that is.
presumption operates.
Yes. But the fact remains that he has not received he has taken a plea that he refused, but if record will call for, my lord, lords will call for the record also, it will be revealed.
This is a 138 case. You want that everything will be done by the court.
No,
You
no,
have
no,
to
that is,
satisfy the-
my lord, since my lord, the manipulation is very much available on the face of record, that is why I am insisting,
Right on,
otherwise
right
I
on.
am not.
The petitioner you are challenging what?
I am challenging the cognizance order, my lord.
The petitioner is challenging the order dated 8/6/2023 passed by SDJM Kandrapada in ICC case number 133 of 2023, whereby the cognizance for offence under section 138 NI has been taken against him. He is relying upon the, he has filed the photocopy of the check, subject check, and argue that the manipulation in the check is quite apparent. Indeed, the check was issued for check of 1 lakh rupees was issued. It was manipulated and it is converted to 10 lakhs. 10 lakh. 10 lakh. 1 lakh you have issued, but
1 lakh, that is admittable.
he further submits that he had issued only a check of rupees 1 lakh.
Yes.
Rupees 1 lakh. 1 lakh. Subject to the petitioner depositing next time 1 lakh rupees in bring.
50,000.
No, 1 lakh you have issued, you give 1 lakh.
But I don't know whether that amount has been paid or not. That
I don't
to my
subject to,
instruction.
I'm not releasing it to the subject to the petitioner depositing rupees 1 lakh before the court below. The further proceeding in so and so and so state. You deposit it, don't release it. 1 lakh.
Yes.
Yes. No, issue notice. Yes.
Item 6.
With your lordship. Lords, here I have challenged an order of cognizance taken by the special judge in the absence of the chemical report. The order is at Annexure 3, and your lordship was
Yes.
pleased to call
Mr.
for.
Maharaj, it is.
Yes.
It is placed.
Yes, yes, it is placed. But there are two decisions of this honorable court. One is Honorable Justice Banerjee, where it has been observed that once cognizance has been taken and chemical exemption has been filed, there is no case so far the accused is concerned. 167(2). Another case.
Am I arguing on 167(2)? I am not arguing on 167(2). I am arguing on the legality and validity of a cognizance which has been taken without the CE report. Where is the question of 167(2) here? I don't argue on the legality or validity of my release of bail or under 167(2).
How have you introduced this legal chemical analysis report on the record?
And your lordship knows this case has been referred to Honorable Supreme Court, which has been not as final order has not been passed. It is pending for consideration. Whether the cognizance is illegal or legal, not filing the charge sheet, chemical examination report at the time of filing charge sheet, that has not been till today. It is pending.
I want to know, how have you introduced the chemical analysis report on the record? Because see, if you file the charge sheet, already you have filed the charge sheet. Once you file the charge sheet, if 173(8) is not open, and you file by way of a supplementary charge sheet, if you can bring some record, I can understand.
Yes.
But you can't bring, you file the charge sheet, final charge sheet, and thereafter you introduce some document in what, under what procedure of law?
In this case, 173 subclause 8 of CRPC, the investigation is kept open because of the chemical examination report. And subsequently, we have already filed the chemical examination report.
By way of a supplementary charge.
Yes, yes. So these.
Supplementary charge sheet file is going. Filed at all. There is no
That's what was the query.
I think the chemical exams report.
Yes, I don't dispute it. I don't dispute that a chemical exam.
He says it's filed. That
it is there on record, but without a 173(8) document.
173(8) is kept open.
Or kept open man.
I need to get the instruction to that extent.
Scan copy of entire university and your call for that.
I can see that.
Where is that? It is there.
My lord, noting that scan copy of an entire proceeding in TR case number 5883 corresponding to Basel PS, Sai PS case number 38. Yep, that will also be.
Yes, More 167(2) पर I don't argue at all. What is pending in the apex court is 167(2). I am saying that an order of cognizance cannot be passed without the CE report. And instead of arguing on that, my lords,
Where is the
Noting there. Let us scan copy of an entire proceeding, TR case number answers.
wasting time of this honorable court. Nothing else.
Kept below the treatment.
No.
Main record. Noting there.
Scanned copy. Rather, I gave it. You
Scan keyboard.
Just report the soft copy may be there. As a report for scanning copy. This is a report for scan. Scan copy will be there. So.
Item 6, na?
Item 6.
6.
The scan of C. I told you, no, it is scan. The copy is not there. No, this is not opening. This itself is scanned, but this is not.
It has been scanned, printed, and is available. Your lordship may see that record where a second supplementary charge sheet has been filed, as my learned friend for the state is contending.
Yes, sir.
173.8 investigation is open, but where is that second charge?
Where is the chemical analysis?
Everybody is being taken for a ride. The courts are being taken for a ride. Justice is being taken for a ride. Procedure is being taken for a ride. We have let people rot in custody, but we need not comply with anything.
Where is that? Have you, Mr. Maharaj, have you seen it?
The LCR, no, I have not.
No, this bunch.
No, I have not.
This is bunch.
It's the upon court record.
It's not there in my, it's not opening up. Where from you got? You got a copy of?
Your lordship's courtmaster handed
over. It is there.
Why it's not opening here?
The soft copy is not opening, but it has been printed and the hard copy is.
It is fine. What color? 71 KB. 71 KB.
They must have given the.
That's it. And give it to Mr. Maharaj. Mr. Maharaj, you just check it out.
I'll check.
And I'll just simply adjourn next week.
Now, I'm placing one line of the order of this honorable court. One line. Subject to correction of my knowledge senior.
Yes.
And apparently I'm accepting all
Second,
the.
my lords, with due respect, my lords. If a judgment is placed, a judgment has to be placed in its entirety. Placing of one line out of context, my lords, renders, my lords, his understanding of the judgment to be also deficient, and my understanding of what he is placing to be deficient. I am just explaining. In that Sheikh Ahmad's case, which my learned friend is seeking to place one line, his lordship categorically stated that the order of cognizance is bad in law and cannot be sustained without the chemical examination being on report. Thereafter, his lordship said that 167(2) is not applicable. Am I asking for bail under 167(2)?
No, I am not on that, my lord.
How is that relevant?
167(2), forget 167(2).
We are testing the validity of cognizance order in the absence of.
Yes. Since your lordship is doing that.
That point I am reading.
Since your lordship
one
is
line,
doing that.
will also make an see.
And since the record has
whatever submission made by my senior, that I have not gone through the records and
So please
whatever
go
I
through the report.
I have gone through the record. That is why I am submitting before your lordship.
Right.
As stated, the what started, as stated, cognizance of the offense under section of the NDPS Act was taken in term of the preliminary charge sheet, right, my lord? And in the meanwhile, as noted, chemical examination report has already been filed. And keeping view the document dictum of the apex court in the case of SRS Pi Supra, wherein an analysis of the provision of section 173 CRPC dealing with the report of police officer on completion of investigation, it has been held that the word shall appearing in section 173 subclause 5 CRPC cannot be interpreted as mandatory but as dictionary. To appreciate the judgment of the apex court, it would be convenient to extract the provision of section 173 clause 5 and 8 of CRPC. 173 report of the police officer on completion of investigation.
That is extracted.
Extracted. Then the conclusion, your lordship, as the honorable court, well, coordinate bench, it is a referred malady has been observed. In the present case, as on 19th day, there were no papers or the charge sheet in terms of section 173 of the code for the concerned magistrate to assess the situation, whether on the merits the accused were required to be remanded to further custody. Though the charge sheet in terms of 173 came to be filed on 5/7/2018, such filing not being in the terms of the order passed by this of the High Court on 3/7/2018, the papers were returned to the investigating officer. Perhaps it would have been better if the public prosecutor had informed the High Court on 3/7/2018 itself that the period for completing the investigation was coming to the close. He could also have submitted the papers relating to investigation be filed within the times prescribed, and a call would thereafter be taken by the superior gazetted officer whether the matter required further investigation in terms of section 173 clause 8 of the code or not. That would have been an ideal situation, but we have to consider the actual effect of the circumstances that got unfolded. The fact of the matter is that as on completion of 90 days of the prescribed period of under section 167 of the code, there were no papers of investigation before the concerned magistrate. The accused were thus denied of a protection established by law. The issue of their custody had to be considered on merits by the concerned magistrate. They could not be simply remanded the custody. Divorce such consideration, in our considered view, the submission advanced by Mr. Dev, London advocate, therefore has to be accepted. We now turn to the consideration issue, namely whether the High Court could have extended the period. The provision of the court do not empower anyone to extend the period within which the investigation must be completed, or does it admit of any such eventuality. There are enactments such as the Terrorist and Disruptive Activities Prevention Act 1985 and Maharashtra Control for Organized Crime Act 1999, which clearly contemplate extension of a period to that extent. Those enactments have modified the provision of the code, including section 167. In the absence of any such similar provision empowering the court to extend the period, no court could either directly or indirectly extend such period. In any event of the matters that the High Court had recorded, its order dated 3/7/2018 was the submission that the investigation would be
ultimately, what is the conclusion?
Conclusion is made. This court is the considered view that the law laid down in Achpal Rameswarapuram Supra has no application in the factual matters of the case at hand. On the conscience of the materials on record, this court does not find any merit in the submission of the London Council that the petition is entitled to be released on default bail, even though charge sheet has not been, chemical examination has not been filed. But subsequently, chemical examination is filed. That has been clearly discussed in this decision, where my Lord Justice B. Narsingh has elaborately discussed about all these things.
That is regarding 167 to
the
question in this case is cognizance is taken in the absence of the chemical analysis. Okay. You say that 173.8 was open. And now you have filed the chemical analysis report. The query of this court is how you have introduced that document.
Yes.
By way of a supplementary charge sheet or simply thrown on the paper like this in the court. This
No.
is one. This is one question.
Yes, yes.
Yeah, that has to be inquiry.
Yes.
And what is the effect if you have filed by way of a supplementary charging? You have introduced that document by way of supplementary charging.
Yes.
Whether the cognizance is taken before the supplementary charge sheet is liable to be quashed, because in the eyes of law it is not a charge sheet. That is what the Supreme Court says is referred to a larger bench. Larger bench, that has to be concluded. So then you have to see from the record to tell this court whether in the due process of law, whether you have introduced that document or the process has not been followed.
Yes.
You just verify
Yes,
it.
well,
So that effect of the introduction.
I have verified, my lord. Final charge sheet submitted, and charge has already been claimed. 5 witnesses have already been examined.
This is the
Situation now.
8 witnesses have been examined. Verification କରିଛୁ ଇଥିରୁ ଜଣା ପଡୁଛି ଏଇଟା ଦେଖୁନାହାନ୍ତି ଦେଖନ୍ତୁ ଆଜ୍ଞା ଅର୍ଡର ସିଟ୍
Anyway, what is the effect of that?
21-24 ରେ ଆଜ୍ଞା PW 7 and 8 have been examined.
Already been examined. Charge failed, my lord.
But if the cognizance has to go, it has to go.
Exactly. It can't. Because this decision has been Honorable two
There are
judges,
other
my lord. Honorable Justice R.K. Patnaik and Honorable Justice B. Narasimha elaborately discussed about all the things. Even if the cognizance is taken before filing of chemical report,
That cannot go.
that cannot
Okay, so
the cognizance cannot go.
Kali, just
Yes.
answer me that
Yes,
part and give me the two judgment.
Yes, sir.
Shall I reserve it?
No, your
Yes,
lordship,
Lordship may
I
reserve
speak to next week. I shall place from this record which is there that what my learned friend
Okay,
is
next
saying has absolutely no relevance.
Next week. Otherwise, I'll
Okay.
reserve it. Reserve the judgment.
No, if your lordship reserves it, I will not be able to
Okay.
place what
Very
my
good.
learned friend
Very
is.
good. Keep it.
I'll not be able to counteract.
Yes, very
Let
good.
it come next.
Okay.
Item 7.
Okay. Seven.
Wait, page notes. Here, my lord, the petitioners have challenged the order taking cognizance passed on annexed 3, my lord,
Yes.
at page 39. Wherein Lord Magistrate was pleased to take cognizance for the offences punishable under sections 498A and 494 of the Indian Penal Code against my lord petitioners.
What happened to that SLP?
It's pending, my lord. My lord was pleased to direct my lord.
See, 5/1/2024, the matter was adjourned
My lord.
because that SLP, pending of SLP.
My lord. It can be ascertained, my lord, by my lord and friends
Counselor, the
office.
Place the order on record and disclose that.
CRLMC 2329/2020.
No. Set up the High Court. Against that order, SLP was
There
preferred.
was an SLP pending.
SLP
SLP diary number 1866 of 2023. What happened to that? See, the order dated 5/1/2024. That reflects.
Yes.
5/1/24.
Yes.
Just take it up.
Here, my lord, the case which has been disposed of by
But
this honorable court.
Since in the order it is indicated,
My lord,
it was strictly adjourned
but on,
because it is sub judice.
yes, but on merit, my lord, I am also saying, my lord, the case of 498A is usually against the relations of the husband or in-laws, my lord. My lord may see the judgment or the order.
One of the co-accused has come.
Co-accused means or husband.
Whatever. He's
And the present petitioner.
Dismissed. SLP is finding.
My lord, present petitioners are the witnesses in the subsequent marriage deed, my lord. Allegation is.
They are friends or something.
My lord.
I know that.
So case of.
Let us see the SLP. First SLP, get the SLP.
My lord.
See, adjourn it.
Yes.
2 weeks.
2 weeks. Day after tomorrow, SLP ascertain कर दे position टा कौन सा पर अपन.
Day after, मतलब
Thursday.
it may not reach also. Today is 101 meters. That's the problem.
April 3 तारीख 4 तारीख आस.
April. ଆପଣ ascertain କରିବେ ଲେଖି ଦିଅନ୍ତୁ. This is unnecessary. We are wasting time. And I'll tell you, this is a husband's petition. It is a matrimonial dispute. His clients are the friends of this husband. Why unnecessary they are untaken, I don't know. Merely because they are friends.
And they
Gave
have,
some good or bad advice to the husband.
and they have been taken as witnesses.
This petitioner, yes, ma'am. This Sanatan Digal. Sanatan Digal is the main person who has been arranged another by a second wife in spite of
490 give the
no
498 देखो
494 আছে 494 he has been charged on
494 भी होगा
and 101
होगा 498 difficult
409
अपन देखो
miss my lord I will verify.
I don't think any case settlement है ही होगी नोटिस है कि नहीं
देखिए
नोटिस है कि नहीं देखो नोटिस करी सेटलमेंट करेगा notice has been issued
no notice
issue notice meanwhile issue notice ठीक है issue notice to opposite party number 2 letter come this will see everything item 8
May I please lordship.
yes
Petitioner challenges the order of cognizance dated on 3 Dihati, wherein the learned exegium to cognizance for commission of offense under section 498A, 307, 494, 406, 506.
where is the charge sheet
My lord, your lordship directed me to file charge sheet, but I could not file. This is the charge sheet.
no, you file it don't do I told you to file the charge sheet last time
Charge sheet dated.
that's the order
Okay.
place on record the charge sheet you are challenging cognizance order at least charge sheet should be there on record
I have brought charge sheet today.
brought me you that direction is to file charge sheet
My lord.
let counsel for the petitioner seeks further time to file charge sheet on record let him do so adjourn
Item 9.
Prayer for expeditious disposal of a vigilance case pending since 2010. Out of 10 witnesses, 8 have already been examined.
10 it's going
of
on
10.
why are you worried
My lord, what I beg to submit, out of 3 petitioners, 2 are suffering from cancer. And only because of pendency of this case, they are
10 ଜଣରୁ 9 ଜଣ ହେଇସାରିଲେଣି 5 ତାରିଖ ଫିକ୍ସ କରାଯାଇଛି ଆଇଓ ପାଇଁ thereafter 3 months they have sought for their lordship allow
write down the petitioners are seeking intelligence of this court no petitioners are facing trial in FIR number 2 first next paragraph the petitioners are seeking indulgence of this court for expeditious for a direction to the trial court for expeditious disposal of the trial out of 3 petitioners let account for the petitioner submits that out of 3 petitioners 2 petitioners are suffering from cancer Mr. Maharana appears for the state submits that out of 10 witnesses 8 witnesses 9 witnesses have already been examined and the next date appearing
5/4/24
it fixed on 5/4/2024 for examination of IO. Therefore, the trial is proceeding at the expected pace. The FIR is up for 2010. 2010. Taking into consideration, FIR is taking into consideration the fact that the FIR is registered in the year 2010, and the accused, 2 of the accused persons are suffering from cancer. It is expected that the trial court should do well to conclude the trial as expeditiously as possible. Yes. Item 10.
Lordship, may kindly pass over this matter.
Pass over. Item 11.
I'm sorry, Lord, I have verified, I have folded it for your Russell can reserve.
Which one?
That charge sheet whether filed with chemical green report or not.
Next week.
এটা আপন তো রিপোর্ট মু নেই
हां रख दियो
সেজবাই ফোল্ড করে দিছি
हां
সেটা ফোল্ড করে দিছি
फोल्ड नहीं था हां
yes
फोल्ड नहीं था I'll reserve the judgment
Item number 10 my lord also said
Item 10 10, pass or is
Yes.
No, my lordship. As per the instruction, item number 6 is not related to item number 10.
I know, but the issue is same. That's what he said. Anyway, we'll see.
Item 11.
May I please, Your Lordship?
Yes.
My lord, the petitioners have challenged the order taking cognizance under Annex of 2, under section 498, 323, 34 IPC and section 4 of a DPI. My lord, Your Lordship, come to the Annex 1, the written affair, the allegations are general and omnibus, and there is every possibility of a settlement. Marriage.
Issue notice to the opposite party. This arising out of matrimonial.
Matrimonial dispute.
When comes for the petition submit that the dispute is arising of the matrimonial dispute and there is a chance of settlement. You have
stay of further proceeding till then. Till there
is a chance of settlement in this present matter, and the dispute is arising out of a matrimonial dispute. And further proceeding
Item 12.
My lord, in this case, the petitioner challenges the order dated 13/8/2018, the envelope issued against the present accused petitioner.
You are in bail.
My lord,
Tell me when you got.
my lord, in my
Tell the date.
I have not mentioned the date, but in my petition in para number 4, I have submitted that the accused petitioner is already on bail, and the order of dated 13/8/18, page number 23, shows the date was fixed for the appearance of the accused persons.
Bail
13/8/2018
Whatever appearance mein thila.
1000.
Mobilized.
Item 13. 13.
Bail. Yes. 14.
13 is a Belgium, my lord.
Yes, but you guys on bail or not, who knows? That's the problem.
Pass over. Pass over.
Yes.
14.
My lord, petitioner arrested, released on bail, and that is mentioned on running page 18.
You tell me the date.
Date 13 released on bail 13/3/2006.
13/2006, NBW 11/12/2017, 1000. Yes.
15.
May I please, Your Lordship?
On or before.
15 का number
Yes. 15.
15.
May I please?
Yes.
And in this case, the accused was arrested, forwarded and released on bail. But subsequently, after submission of the charge
Maybe you
sheet,
tell me when you were on bail, when you got the bail.
Bail date का जानते हैं? Bail date जानते हैं? जानना थी? ये लॉस में
On
अगर
bail got this.
Yes, sir. ठीक है.
500.
Yes.
27/2/2023.
Item 16.
On behalf of Mr. Ponda, may it please, Lordships. Belgium matter, Lordships.
Hmm.
Lordships, earlier he was on bail, but he has, I have not mentioned the date to Lordships, but I have, in paragraph 2, I have
You are on
stated
bail
that
or not?
I am on bail, Your Lordships.
Bail. No date is there.
No date is there.
Bail on bail karo. 31/2/2020.
Yes.
100. 500.
Oblique.
Yes.
17.
Belgium matter, my lord. He was on bail on 19/5/2022. NBW issued on 16/3/2023.
Date का ठीक report.
He was on.
आराम रखो, कौन आला problem?
He was on bail, my lord, on dated 19/5/2022.
19/5/2022.
NBW issued on
24. 16/3/24.
23.
24 you have written. In annexure you have written.
18 my lord.
Kind of 23. 16/3/23. ठीक है? 1,000. Yes.
18, my lord, Belgium matter, my lord. Bail was granted on 4/4/2019 and the NBW was issued on 5/8/2023.
500.
Well, beg pardon, item 82, any other date, maybe.
82.
82.
Oh, who is
No interim order has been passed.
there is no other side? 82 at them.
My lord, item 80 also, 1 week time, no interim order, the defect I'll remove.
Somebody is appearing, no.
80, no, my lord, fresh case.
Fresh
Defect,
case, 80.
defect I'll remove within 1 week. 80.
101,
Obliged.
130, NIB after 10 days.
101.
101.
Revision. Revision. What was the check amount?
I think 1,20,000 something. I have not contact with them, contact the consumer. There is a lawyer.
If you can pay it and we'll finish it up.
No, I don't. I have not in contact. That is the okay. Because I don't have any work. Otherwise, I would.
Next week?
Week back.
2 weeks.
I'm trying to switch.
2 weeks.
Because I have to
79.
letter.
79.
I'm not able to contact.
79 lordship. The notice was issued by lordship, but the return the postal documents returned address left your lordship. I will take fresh notice in fresh address.
72 na?
79 lordship.
79. Fresh notice.
Interim order continue lordship. Obliged.
Lordship, 95 and 98 LCR is not, 95 and 98 LCR is not received.
Let us see.
Item 100, my lord. Time to be taken after 1 week.
Everybody will seek adjournment. You render the court unemployed. Chalo for the revision.
100. 100.
100 revision, na? Revision. No, nobody is willing to do revision.
আমি তো রেডি কি আসছে পরিবেশ না আর্জন করে দিলে কেমন আমি কম করি
So since the last 1 month, a single revision is not heard.
ওটা তো at least করো
Do you know 10,000 revisions are pending in this court? 10,000 revision.
Okay, sir. After 1 week.
Everybody will seek 1 week, then how the things will start moving? 10,000
yes
revisions. And many of them might have been infractious also. Many of them might have died out.
died also. That is the whole.
The whole
record. That's it. That's why let them to adjourn, but they should take
What
further.
we will do is in one of the day, we will list at least 50 revisions.
Yes.
And streamline everything.
Yes, my lord, for verification and
Verification and all, so that thing will start
yes,
moving.
yes.
In one date you find out whenever there is bail matters, only Monday, Tuesday, at least 50 revisions. Let us see. So that we can understand how many of them are infractions. Out of 50, 20, 30 might be infractions also. We'll finish it up at least.
Okay.
କିଛି ରଖିନି ଆଗେ ରଖୁଛି What are the 498? 13. Belgium will allow. Can you assist me where the?
Yes.
No, in the absence I can't do because I have to record his undertaking.
Yes.
Arjun,
you are
Item 20.
Yes. Charge submitted under section 376 AB is there, madam.
376
AB. 6.
May please, my lord, allegation is under section
20B of NDPS Act, nothing, amount of ganja is 22 kg, 22 kg 50 grams. Obliged.
Outsider or?
No, of Hon'Ble district.
22.
May I please, your lordship? Lord, here the magistrate tribal offences have been, my lord, FIR has been registered 457,380, my lord. 457,380.
What is the allegation?
Allegation is ଗୋଟେ ମନ୍ଦିରରେ କଣ ଗୋଟେ ଇଏ ଦାନ ବାକ୍ସରେ 1500 ଟଙ୍କା ଖଣ୍ଡେ ଥିଲା ତାକୁ ନେଇକି
ଭାଙ୍ଗିକି ନେଇଛନ୍ତି।
ତାକୁ ଭାଙ୍ଗିକି ନେଇ ଯାଇଛନ୍ତି। So far as this man is concerned,
are there against you?
ଏଥିରେ actually ମୋ against ରେ କିଛି material ନାହିଁ।
How many cases?
ଗୋଟେ କେସ୍ ଆଗରୁ 395 ଥିଲା ସେଇଟାକୁ ବେସ୍ କରିକି ସେମାନେ ଏଥିରେ ମତେ ଧରିଛନ୍ତି।
People target the ATM. This
No,
ATM.
ସେଇଟା
And you target temple.
Donation box.
Donation box.
915 ଟଙ୍କା ତାଠୁ ବାହାରିଛି। That is again, and he is in custody since ଗୋଟେ antecedent 39 ସେଇଟାକୁ ବେସ୍ କରିକି ଏଥିରେ ଧରିଛନ୍ତି। Actually this case
he was arrested there.
There he was arrested and he has been released on bail. And ଏଇ case ରେ ଏଟାକୁ ଧରିଛନ୍ତି because there is a 395 case against this man. So ସେଇଥିପାଇଁ ଏଥିରେ ନହେଲେ FIR is on him.
The petitioner is accused and so on. So the allegation against the petitioner is page 9 allegation. For the state and submits that the petitioner has one more case against him. One more similar case against him. Being which case number being?
ତାର ନମ୍ବରଟା ହଉଛି PS case number ଟା ମୁଁ ଲେଖିଛି ଏଠି PS case number 160 of 2023.
One PS case which year?
এটা সোনপুর PS case.
Sonpur PS case number
160 of 2023.
160 of 2023. The petitioner is in custody since?
Custody since 9/1/2024.
9/1/2024. 24. 2 months. Let it
More than
2 months. For 2 months you will have to appear before this. 2 months, huh? Sunday, every Sunday. Yes. 27.
My lord, this is a case offense under section 363, 376, 2 and section 6.
Fast offender.
52
grams.
Less than commercial quantity, fast offender. No,
Fast only it starts. Thereafter, once you are encouraged, then you start.
Any stagnant condition, if I will commit my
At least acid
more than 1 month in custody.
1 month matter right.
Fast offender.
Upon CDN. Wait. Brown sugar. Otherwise,
My 35, my lord, nothing has been seized from the possession of the petitioner. Custody from 17/10/2023. Acid has been filed.
Brown sugar again. Brown sugar.
20 grams from other co-accused person. Nothing has been, the executive magistrate has sourced from 10 grams from one Sadasiv Naik and 10 grams from Ajay Varta. Nothing has been, the lordship, turned to page 10.
Nothing is seized from you.
Yes, fourth line from
Balabhadra Behra.
Yes, nothing has been seized. Acid has been filed.
Where is that state?
Page 10, my lord, your lordship kindly see. Fourth line, conducted personal.
Where?
Page 10 of the
10.
Page 10.
Okay.
As per direction of executive magistrate, I also conducted fourth line. From the
एक मिनट
conducted personal.
1 minute.
Suryakant Parida.
1 minute, sir. Let me get it first. Where is that? As per the direction of EM. Executive magistrate, I also conducted the personal search of three persons, namely Suryakant Parida,
son of
Braja Kishore Parida, and
Sudipta Naik.
Son of
Then third my lord, Balabhadra Behra. Nothing incriminating were found, my lord.
Where is that Balabhadra Behra? Son of so. For that, nothing incriminating were found.
Charge sheet has been
But in fact, the petitioner will supply the brown sugar to the from whom the brown sugar is covered.
That is Sadasiva Naik. Page 8. Sadasiva Naik.
Where is the allegation against you?
Allegation is that is the allegation. And your lordship kindly see page 8.
No,
They
page
solved-
10, second paragraph. During interrogation of the accused Sadasivo, such and such,
That is confession.
and Ajay Parida, Sudipta Naik, and Balabhadra were the petitioner, alias Balia, such and such place, supply them brown sugar in a purpose of sale. And they
I have no
along with the
similar nature of
project-
antecedent, not a single similar nature of antecedent, madam. Only your lordship page time,
These
page
petitioners supply to the
no, page
accused
8,
from whom they.
page 8 your lordship kindly see.
Brown sugar.
1 minute, one after another only. I can't think.
Page 8 your lordship kindly see. Third line. I received information from reliable sources that one Sadasiva Naik, alias so and so, will deal brown sugar business with 4 other accused persons. That is Sadasiv Naik, from whom 10 grams were chased. And from other accused person, 10 grams.
All of them, my lord, were in the house of Sadasiv.
But see,
and
so far as he is concerned, nothing
Nothing
is
has
recovered.
been seized.
Some
my
2 persons, my lord, that has been recovered, my lord, 10 grams each, my lord.
10 grams.
Subsequently, they confess that these petitioners supply the brown sugar to them.
7/10/2023, charge sheet has been filed.
Let
He is the supplier.
Let him attend the police station.
Yes, ma'am.
For how many months?
But charge sheet has not been 4
Charge sheet has been filed.
4 months, sir.
4 months.
4 months.
Therefore, the petitioner is accused himself. The allegation against the petitioner is that he as per the statement of the co-accused from whose custody, whose position, 10 gram of brown sugar was recovered. It is realized that the petitioner has been supplying the brown sugar to these accused persons. In the FIR, it is also indicated that as per the direction of executive magistrate, search was conducted from the 3 accused persons, out of whom Suryakant Parida, from the position of Suryakant Parida and
Sudipta Naik and the
Sudipta
present
Naik,
person. Nothing has
10 gram each, 10 gram brown sugar each was recovered, whereas insofar as the present petitioner is concerned, nothing is recovered from his position. Nothing is recovered from his position. Taking into consideration the period of custody and quantity of contraband involved in the present case. Grant bail 4 months every Sunday. Yes.
Pardon and mention, my lord, item number 13, my lord. Kindly take off, my lord.
Belgium.
Item number 13, Belgium matter.
You come at your own pleasure. In the morning I passed over, and after passover also you don't come.
Sure. Sorry, my lord.
What sorry? There should be some decorum of the court. Anytime as per your pleasure you come. It's court proceeding. We are not here to mobilize the.
Can't you tomorrow, my lord?
Maintain something. Why you are not there in the morning?
On the court.
And after passover at 2 o'clock, you know that 2 o'clock I am taking up the matter.
Sorry, my lord.
Don't even repeat it. Yes. You are on bail? You are in bail or not?
It's CLMC, my lord.
I know that you are in bail. Your client was on.
My lord.
When?
My lord, challenging NBW order dated 16 January 2024, my lord. Page 11,
I am
Annex 1.
asking you whether your client was on bail or not.
Yes, my lord.
Date, give me the date.
My lord. 7/12/2023, my lord. Page 9, my lord.
2023 NBW 16/124 500. Yes. Next.
36.
April, na? Everybody will April.
Case of extortion, my lord. After 4 years, I have been arrested on the strength of the NBW. This is the case of 2022, my lord. On basis of co-accused statement, I have arrested, my lord.
What is the offense?
Offense 384, 507, 506, 34 IPC, my lord.
Yes. What is the allegation?
Allegation against me, my lord, that the co-accused persons that I was present on 27 January 2020, but when the co-accused persons called to the contractor for 1 lakh rupees, that day I was present. That was exposed by the co-accused persons. And on 13th January 20, when he was again there to the spot, he was red-handed by the person concerned, by the villagers, and one person has escaped. But after arrest, he disclosed that I was there. And
What is the allegation?
My lord, allegation is that, my lord, they demanded, my lord, money, stating there in that they are belongs to Mahavadi, and ask your contractor to give rupees, my lord.
1 lakh.
Otherwise, they will kill the contractor, my lord. These petitions, my lord, absconder, charge sometimes showing them absconder, and in person to the NBW, after some charge NBW issued, in person to NBW, they have an accident.
You have the contact, what to do?
Yes, my lord. I was arrested 4 years after.
And
Only on basis of co-accusation.
Whatever, but you are absconding and you are threatening you. That
No, my
you
lord,
are-
I have not stated.
In this case, my lord, we said they are belongs to outside state, my lord. But a CD and antecedent is required, my lord.
CD and
37.
37 may I please speak?
Yes.
37 my lord, the offenses are under 302 120B and 34 of Indian Penal Code, my lord.
CD.
My lord.
Yes.
43.
My lord, the petitioner is custody since 11/1/2024 under section 20B2C 25, 28, 29 of NDPS Act, my lord. My lord, the petitioner is the passenger, my lord. And a total amount is 51 kg, 600 gram.
No, everything is all right. Where is the FIR? You have not filed a single paper except to the rejection order.
My lord.
Where is the FIR? What is the stage of investigation? Nothing is there.
My lord, এটা পছরে মিললা।
What's the file it? Then comes for the petitioner 6 time to file additional document to substantiate his case, release the matter. Yes.
46.
May I please, your lordship? Offense under section 3762N, my lord, 506. In this case, my lord, the petitioner has surrendered on 1/9/2023, my lord. After surrendering, the offense under section 6 of the Postal Act has been added. During when the CD has called for, the police has added
CD
the
is called
seconds.
proceedings.
My lord, in this case, a charge sheet already been filed. I have the certified copy of the 164
Let me-
and medical evidence
You
also.
file that also, I'm asking for CD. Yes. CD. You
47.
file those documents. Yes. 47.
47.
Your lordship, I pray for kindly one pass away, your lordship. Learned senior is on his legs, your lordship.
Pass over.
52.
My lord, 52. We have put urgent to next week, my lord.
Urgent.
Problem.
53.
My lord, 53 and 54,
Hmm.
in respect of the same petitioner, here the background is, my lord, 8 cases is pending against him, including the present case. The background of the case, my lord, I have given an affidavit. There have, in the affidavit, I have mentioned that present petitioner, he was arrested in the month of April 2023 in Joda PS case number 101/2023. When he was arrested and in custody, he has been taken remand in 3 cases, my lord. That is Turmunda PS case number 23, the present case, my lord. Thereafter, thereafter Champua PS case number 14 of 2023 and Champua PS case number 41 of 23. So after his arrest in another case where he has already been granted bail, thereafter he has been taken remand in the present case along with 2 other cases, my lord. That affidavit already out of in Champua PS case number 14/2023, this bench has granted bail. I have got the bail order, my lord.
Where is the comprehensive affidavit?
That is, I have already given, my lord. Already in the record.
What have you said there? I'm the mother of the
Relates to all cases I have filed. I have a copy also. Your Lordship. So he is already 1 year in custody, and one of the case this court has granted bail, and charge sheet has already been filed. It is a remand case. It is not the case he has been named. After co-accused statement, he has been implicated and taken remand. Madam. Yes, the 3 cases, 1 case this court has granted bail, and present 2 cases is before your Lordship.
Which case?
I have given in the affidavit. Co-accused jaichi eta affidavit. Video achi?
Go to flag C.
Flag C. Flag
In
C.
this case, co-accused has been granted bail.
Yes, ma'am.
In this case.
Yes. In the present
Give me the
case,
particular of the co-accused. Write down. The petition is taken in this term. The allegation against the petitioner, 12/1/2024 order, પછી પારા 3 દે. तापर लिखियो the coordinate bench of this court by order dated 12/1/2024 on 12/1/2024 directed the petitioner to file a comprehensive affidavit disclosing the number of cases registered against him. The petitioner has filed a comprehensive, the mother of the petitioner
yes, ma'am.
Has filed a comprehensive affidavit dated 20th February 2024 inter alia stating that how many cases you have?
Including present case, 7 other cases there.
6 cases.
Yes,
disclosure stating that the petitioner is involved in age many years. 6 cases, the age many years, 7 cases, including the present one. The written account of the petitioner submits that in all the cases he has already been granted bail. He further submits that on the when he was in custody in one of the cases, his client he has been on remand in the 3 cases, including the present one. Including the present. These are matter of 40 including present one. Okay. Allegations are different. So check it. Now 54. 54. 152. BLA, 153.
53 sala 54.
53 comes. Now, the petitioner is relying upon the judgment of coordinate bench passed in BPAL number 83 of 2024 and BLAPL 79 of 2024, wherein the accused co-accused persons has already been enlarged on bail by the coordinate bench by its order dated 18/1/2024. Taking into consideration the run debate. However, the petitioner is directed to appear before the IIC. Which IIC?
IIC, the address of the petitioner shows, my lord, and he is a resident of Keonjhar.
Joda na Koda?
Choda, PS Joda.
PS Joda. Every Sunday for 6 months, because you have a lot of cases for 6 months. Next 54. 54 record. 54
And mother also filed.
Three direction is like comprehensive.
ସେଇ ଜିନିଷ ଏଠି ଖାଲି ପ୍ରେଜେଣ୍ଟ ପିଏସ୍ କେସ୍ ଥିଲା ଚମ୍ପୁଆ ପିଏସ୍ କେସ୍ ନମ୍ବର 41.
Allegations are there in yes, page 7 allegation that is page 7 अरे मुझे लगी तो फाइल को तो ठीक है नहीं हो अब सब सेम कर दो ठीक है कॉम्प्रिहेंसिव एफिडेविट नहीं बाय ऑर्डर डेटेड 12/2/2000 नहीं हाँ by order dated 22/1/2024 the petitioner was directed to file comprehensive affidavit disclosing the antecedent mentioned. In pursuance thereto, a consolidated affidavit has been filed by the mother of the petitioner.
Yeah, the same petitioner, Tarima.
Mother of the petitioner, Entralia, stating that you should sign like the paper. ठीक है.
Obliged.
Yes.
The 8th. May I please, your lordship?
It is a case, my lord, related to cryptocurrency on earlier occasion. Your lordship, the self-same cause of action flagged AM is the judgment copy, wherein the two directors of the same company, wherein the present petitioners became an employee, had already been got anticipatory bail, my lord. To that effect, they have some.
So may remember on last occasion on 4/3, lordship was while fixing the matter today. Whether we have gone challenge the order of this honorable court passed in
the two directors case.
Here the opinion has already been sent to Home Department because of the intervening already for last 3 days. The matter could not be filed as yet, but it has been processed. Your lordship may call it in the next week. I will publish the case number.
I will allow this petition also. You file another SLB, 3 SLBs.
Your lordship knows better than anybody else.
Awaiting your, you would be filing something, so why should he be in the
That was my non-point is not correct. That was neither under the crypto. This is also not under the crypto.
But he is an employee of a company where the directors are granted bail and the money is transferred to the director's account. He nothing is transferred to his account.
He is a authorized signatory, my lord. He has dealt with 135 crores of.
No. That is.
Also, can you see the gravity of the offense, my lord?
But
they are
maybe, but the problem is the co-accused has got the bail. That's the problem. And they are directors of the company.
Absolutely correct, my lord. There cannot be any. My lord, I have placed the matter.
I'm only on the question of parity.
My lord, I don't say, my lord, that I only ask for your lordship's indulgence for giving me one more chance.
Okay, by way of last and final opportunity,
Lord, I am seeing
the Mr. Counsel for the opposite party given an opportunity to seek instruction in this matter. Please, the matter on 19th I'm listing. 19th. You are entitled to bail. I'm saying if a SLB is filed within 1 week, no order.
My lord,
you know that.
My lord, what I am submitting. No, my lord, what I am submitting.
The only thing is
within
one more week you will be in the custody.
Within 2 minutes, my lord. What my lord and senior says. It is not a case about crypto. Okay, my lord.
I'm not going into all these things. Wait till 19th.
My lord is saying about the parity.
Parity. You are only on parity because see the amount involved.
Now that amount, the caption matter, my lord. I submitted one thing. The basis on which the FIR has been registered, that is the Vijay Kumar Nath.
Anyway, we will go into
the amount which has been invested Vijay Kumar Nath either comes to the petitioner's company.
Let him argue on the whether you are entitled to parity. As of now, it appears that you are entitled to parity. He may distinguish it also.
Now my case is similarly situated fact and circumstances.
Let us see. 19. By way of last and final opportunity, I have said.
That is last chance, my lord.
Yes, last chance. I have written. Yes.
67.
Wait, please, your lordship.
The FIR has been lodged under section 341, 324, 307,
Yes.
294 and 34 of the IPC, my lord. The charge sheet has been submitted under section 341, 323, 307 and 294. The entire family members were implicated in this case in the FIR.
What have you done?
The quarrel between the neighborhood quarrel, my lord. A bucket was there in front of my house, and the alleged injured that kicked that bucket. Thereafter, there was a dispute between two groups, and the entire family members were implicated here. And there is a counter FIR also in this case, my lord. So they are in the
You have
custody.
filed the counter. You have filed the affidavit.
Yes,
Sorry,
my wife.
FIR.
FIR. Counter FIR is there. The same number, just one. That number is. I have annexed that FIR also, my lord.
Which one? This you are the FIR in which you are the accused is 641.
Yes, then that is 642, my lord. The counter FIR.
642. correct.
Yes, my lord. And they are
1 minute.
and the injury is simple in nature, my lord.
5 minutes here and there. Yes.
Yes, my lord. And there
Injuries are simple. Yeah, Mr. Maharaj.
But here the specific allegation against the petition number 2 and the injured sustained 3 incise wound on left frontal parietal area, right frontal parietal area, and on anterior neck.
Simple.
But that is
simple in nature, my lord.
charge sheet has been filed.
They are in custody
You are in
since
custody since
30 of 2023, my lord.
देखो, petitioner is an accused in FIR number so and so under section so and so. Investigation has already been completed and charge sheet has been filed.
Yes.
And the medical examination report of the victim indicates that the injuries are simple in nature. Consequently, the petitioner further submits that pertaining to the same incident, a cross FIR being PS Kharbel Nagar case number 642 na
642.
642 of 2022 was registered simultaneously.
Yes.
Simultaneously with the FIR in which the petitioners are accused. Mr. Maharaj appears for the state and
My lord, FIR number 641, they are accused.
I know that.
Yes, my
lord. Submits that the insofar as petitioner number 2 is concerned, there are specific allegations against him. And antecedent?
No antecedent. No antecedent.
You are the same village, same.
They are brothers in the same village, neighbor.
Accused.
All are in the neighborhood, my lord.
They are brothers, huh?
The petitioners are brothers.
What about the informant?
They are the neighbors.
Petitioner, the petitioner and the informants are neighbors. And due to a small misunderstanding, the quarrel has taken place. It is the heat of court, heat of the moment.
Obliged to lordship.
72.
Well, the petitioner is in custody since 21/2024 for alleged offense under section 147, 48, 448, 294, 506, 427, 149, and 2527 Arms Act. This FIR story is, my lord, on 17/11 ରାତି 11:45 AM ପରିବାର ସହ ଆମେ ଶୋଇଥିବା ସମୟରେ ଏକ ଭୟାନକ ଶବ୍ଦ ଶୁଣି ଆମେ ଉଠି ଦେଖିଲୁ 20-25 ଜଣ ବ୍ୟକ୍ତି ହାତରେ ଖଣ୍ଡା ଭୁଜାଲି ବନ୍ଧୁକ ଧରି ଏକ ହଳଦିଆ ଜେସିବି ମେସିନ ସାହାଯ୍ୟରେ ଘର ଭାଙ୍ଗୁଛନ୍ତି। ଆମେ ହଠାତ୍ ଆସି ପ୍ରତିବାଦ କରିବାରୁ ତୁମେ ପରିବାରକୁ ଜୀବନରୁ ମାରିଦେବାକୁ ଧମକ ଦେବା ସହ ଆମେ ନିକଟକୁ ଚିନ୍ତି ଆସି ଥିବାରୁ ମୁଁ ଓ ମୋ ସ୍ୱାମୀ ଝିଅ ଚିତ୍କାର କରି ଏକ ଘର ଭିତରେ ପଶି କବାଟ ଦେଇଦେଲୁ। ଆସାମୀ ମାନେ ଅସଭ୍ୟ ଭାଷାରେ ଗାଳିଗୋଲଜ କରିବା ସହ
Anyway,
ତ
yes, I understood, but where charge sheet is filed, so many people were there.
no,
Have you
no
identified?
one has
Investigation.
You are not identified.
Investigation.
How many people were arrested?
no only the petitioner, my lord. No one has arrested.
Because
One, two have been named. Nakula Lenka, Gogon Lenka have been named. Other accused persons are there.
what is the role?
Your lordship may see the FIR. In the FIR, she has stated ସମସ୍ତଙ୍କ ମୁହଁକୁ ବାନ୍ଧି ଆମ ଅମୁକ ସାହିର ଅମୁକ ଲୋକଙ୍କ ସହିତ ଆମର ଇଏ ଥିବାରୁ ଆମେ ତାଙ୍କୁ ସସ୍ପେକ୍ଟ କରୁଛୁ।
But Nakulo Naik,
ନକୁଳ ନାୟକ ନାଁ କଣ ଲେଖା ହେଇଛି ଦେଖୁନାହାନ୍ତି ଏତାଲାଟାକୁ?
FIR.
ଆଜ୍ଞା ଦେଖନ୍ତୁ, if your lordship will look at the FIR at page 7, your lordship may see the your lordship may look at the line 10 lines from the bottom below. Below the line OD 33M441. ଯୋଉଥିରେ ଗୋଟେ ଗାଡି ନମ୍ବର ଲେଖା ହେଇଛି OD 33M4413, ତାପରେ କଣ ଲେଖା ହେଇଛି ଦେଖନ୍ତୁ, ସମସ୍ତ ଆସାମୀ ମାନେ ମୁହଁରେ କପଡା ବାନ୍ଧିଥିଲେ।
but I think the OD 33 what is that number?
ସେଟା ହଉଛି ବା ତାଙ୍କରି ଗାଡି।
Who owns this?
ଆଜ୍ଞା ଇନଫରମେଣ୍ଟ ଲେଖିଛି ମୋ ସ୍ୱାମୀଙ୍କ ନାମରେ ଥିବା ମାରୁତି ସୁଜୁକି ଆଲ୍ଟୋ 800 ଗାଡି ନମ୍ବର OD 33M4413 ଗାଡିକୁ ବାଡେଇ ଭାଙ୍ଗିବା ସହ 2ଟି ମୋଟରସାଇକେଲ ବାଡେଇ ଭାଙ୍ଗିଛନ୍ତି। ମିସ୍ଚିଫ୍ 427 ଆଜ୍ଞା। ତାପରେ ଆଜ୍ଞା ଦେଖନ୍ତୁ, ତାପରେ କହିଲା ସମସ୍ତ ଆସାମୀ ମୁହଁରେ କପଡା ବାନ୍ଧି, ତାପରେ ଲାଷ୍ଟ କୁ ଲେଖିଲା ନିମାପଡା ଓଣ୍ଡିଆ ସାହି ନକୁଳ ଲେଙ୍କା ପିତା ନାଥ ଲେଙ୍କା ଗଗନ ଲେଙ୍କା ପିତା ନାଥ ଲେଙ୍କାଙ୍କ ସହ ଆମର ପୂର୍ବ ବିବାଦ ରହିଥିଲା। ଏମାନଙ୍କ ସମସ୍ତଙ୍କ ଘର ଖେଦରପୁର, ଥାନା ନିମାପଡା, ଜିଲ୍ଲା ପୁରୀ। ପୂର୍ବରୁ ମଧ୍ୟ ଉପରୋକ୍ତ ଆସାମୀ ମାନେ ଗଣ୍ଡଗୋଳ ସୃଷ୍ଟି କରିବାରୁ କଣ ଥାନା ମାଧ୍ୟମରେ ସମାଧାନ ହୋଇଥିଲା। ଆଜ୍ଞା ତମର ଗଣ୍ଡଗୋଳ ଥିଲା ରାମଦାମଙ୍କ ସହିତ, କିନ୍ତୁ ସମସ୍ତେ ତ ମୁଠା ବାନ୍ଧିଥିଲେ, TI ପ୍ୟାରେଡ ନାହିଁ। And what are the offences, Millers? The offences are all
Yes, Mr. Maharaj.
triable by a magistrate, Millers, and my learned friend is saying investigation is going on.
Yes, Mr. Maharaj, you can. Yes, finish.
Then ମୁଁ ଯାଇ ନିଜେ investigation complete କରିଦେଇକି ଆସିବି।
ନା ଆପଣ କେହି କରିବେ?
This case diary I have received. This is not so easy to make a mention and taken a plea that this is only 506. This is a case where your lordship may kindly see, had it been a case of argument made by my junior friend, I would have said nothing. But my senior has placed this matter, so
You want to
I am having this.
both your senior.
But my case is this Nakul have been.
That's the reason tactically.
Yes.
Mr. Ponda has employed him to argue.
No,
So that
your lordship told that your lordship will hear it.
Yes.
I said you should do
This
it.
petitioner,
yes,
But because
engage
of
the lighter vein. These are
because he could not claim this fact, I had to write.
this petitioner, my lord, having civil dispute and civil case is pending before the concerned court. Both are parties to that civil proceeding. A order has been also passed that you should obey the order of the civil court. After that, this petitioner engaged one Prasanta Kumar Parida, whose JCB was indulged in this case. He has given 20,000 rupees to Prasant Kumar Parida. You come and destroy the house. He admitted on his confessional statement that I have given 20,000 rupees to Prasant Kumar Parida. Accordingly, my lord, during course of investigation, that JCB has
he confessed.
Yes, and that JCB machine has been seized.
Confessed before who, my lord?
That's true.
Confessed.
That corroborated to the JCB machine, and the entire building, the entire house has been destroyed, including the car and the motorcycle.
The car and where is the house? House doesn't.
Yes,
doesn't
your lordship, I have given the.
More
ଏଟା କଣ ହବ 302 ହବ ନା 427?
25, 27, 25, 27 Arms Act is there. Had it been not there, then I would have no case. I could not have said anything. These things have been happening in the midnight. What is the intention behind
What
it? Where they will stay?
Antecedent.
Antecedent, my lord, is not there, but civil case number is there.
Of the 6 months, they should go and appeal.
Right.
No antecedents.
But 6
No,
months,
no,
because see, you are creating such mischief in the midnight.
Me.
Of course, you are there.
My lord, I have read that new act also. जो कौन साक्ष्य अधिन ସେଥିରେ ବି confession before a police officer.
Not on confession.
No evidence.
Not on confession. Not on confession.
ଆଉ କଣ?
Looking into the fact that you have hired
machine କଣ
no, no. Maybe or technically prosecution might not have a case, but practically what had happened, you know that.
ମତେ ଦୁଃଖ
Right.
ଲାଗୁଛି ଏତିକି ହାଇକୋର୍ଟରେ ଏଇ ଦଫାରେ ଏତିକି
Anyway, right on.
ଆପଣ କରିଥିଲେ ସିଧା ଗୋଟେ ଜୁନିୟର ଶିଖୁଛି
Allegation
ଶିଖିବାକୁ ଚାହୁଁନି
midnight of where is that rejection order ଲେଖା ହେଇଥିବ.
ମୋର କଣ ନାଁଟା ଲେଖିଲି ମୁଁ ସ୍ୱର୍ଗକୁ ପଳେଇବି ନହେଲେ ମୁଁ ନରକରେ ବାସି
Bara, please, 12. Allegation against FIR. ठीक है. Mr. Maharaj appeared for the state and submits that there are civil dispute pending inter se party.
Yes.
And investigation reveals that he has the petitioner investigation the confession of the present accused. On the basis of the confession of the present accused, it came to the light that he has hired a JCB from one Prashant Kumar. So and so.
Prashant Kumar Purida.
Prashant Kumar Purida, and employed the same JCB for the purpose of destroying the properties of the informed. Since the confession before police being not admissible in the court of law, no credence should be given to the said confession. Having taken into consideration all the facts and all, 3 months he will appear before. 3 months at least you appear before the IAC, so that at least some check and balance. You will not create
every day now, once a week.
Once a week. That's Sunday once a week. So that some check and yes.
Definitely.
The prosecution should also be happy.
Balancing act.
वो आप तो सीखेंगे आपको किसी को आराम से साथ में बोलते हैं
75. Sometimes senior appearing is detrimental. 75. Yes. Adjourn. 76. Delhi Kumar Malik adjourn. 77. Yes.
May it please, Your Lordship. The OPID council, my lord, is on the opposite party. Copy the. Yes, my lord. Let me just begin. Not here I am challenging. In fact, I am not challenging any order, but it's a very peculiar case where the CRPC is silent regarding my remedy. In as much as if my property has been fraudulently given as security in case of a bail, then whether I am entitled to get back that property upon my showing of the ownership, and the court says that because it has been under attachment of OPID, till the disposal of that, I am neither a party in that the OPID. I am not an accused. I am not a witness. I am not a victim even. So whether I have just filed that the property which has been given for bail of the accused is my property, which he has fraudulently given.
He has given fraudulently.
Yes.
And
the accused.
you have initiated any case against him?
No, I have not initiated. That is different. The financial depositors who have deposited pursuant to the scheme floated by that person for apartment.
Why have you not initiated any case against him? Your property is entangled.
Right.
That may be a case.
I have initiated under 443. That is 443 of CRPC says in case of fraudulent deposit of surety or security, then the only remedy is the accused will be put inside custody and his bail shall be cancelled.
Yes.
That is only the remedy. Now that is not what I am praying for. I am praying that my property be released in my favor, which I am the rightful owner.
Have you moved application?
Yes.
Trial court.
Yes.
Trial court rejected it.
Trial court has rejected, saying that it is subject matter of the civil miscase. That is after the distribution of the properties on conclusion of the proceeding, then only you can be heard.
How that property is linked with the accused?
That accused had taken that property on a notary affidavit, stating that he will build apartment on that property. That property is inclusive of other persons.
You
too.
have also signed there.
That is a notarial affidavit.
Whatever, you have signed there.
Yes, I have signed there.
That is how you misrepresented the somehow. It may be not valid document. Therefore, this property is now entangled.
Subject matters. What has happened? The accused approached this honorable court in a bail
In the
application.
absence of that notary document, you had a case. Since the notary document is there.
But notary document ab initio is void for any.
That's a different story. In a criminal prosecution, are you asking for a declaration?
No, my lord, not a declaration, but
That
yes,
is
your
how
lordship.
you mischievously notary document you have done and you misled the people. That's the case.
No, I am not an accused. I am the owner of that property.
But you were with him.
I am
Notary document, you have created some notary document with the accused.
in favor of the accused.
In
Yes.
favor of the accused, and he used it. And what
And
action you have taken? If you are so clear about it, you should have taken action against him. You are not keeping silent because you are partner.
No.
Both of you are doing all
No. FIR has been lodged. FIR, the action has been taken. He has gone on bail pursuant to the FIR by the depositors, not by me.
Have you taken any action saying that why have you involved my property?
I could not have taken in view of the order which has been passed in the bail application. That order in the bail application
What for good reason this notary agreement you have signed?
for development of that property, and I will be given an apartment in that property. That is the only the thing, that he will develop that property. He will give an apartment in my favor.
Difficult, sir, because of this notary. Annexure 2.
Notary that I am conscious, but I could not have gone against him in another application or proceeded against him because in view of that order passed in the bail application, where the bail application says that he be released on a security of 3 crores, and it says from among that the property which he has surrendered for valuation in favor of the police has given a valuation report of 8 crores of the entire property. So from among that property, 3 crores it's to be given as solvency to the.
Two ways this property is involved. One is you stood as a surety for the accused, and this property was involved.
I have not stood as a security. The petitioner is no way connected in the criminal
Show me
proceeding.
your application before trial court. Have you
Yes.
said these things?
Yes. No.
Show me.
That is page 65, annexure 6.
Yes. Show me. 443 application.
Yes, my lord. Now page 65, the nomenclature is application are 443 CRPC. 443, if your lordship permits me, I can read.
Show the relevant part.
The petitioner here is the lawful title holder of a removable properties consisting of such and such corresponding to such and such. Now that one Priyadarshi Das having lodged FIR, the second paragraph, lodged FIR in Sadev Kunta PS case such and such, was registered again, investigation was taken up. and has submitted charge sheet against the accused persons and another his partner of Sai Infrastructure as partnership firm, and has collected deposits from the public promising to provide sale flats in their project in the name and style of Sri Sai Popular Tower located at OT Road such and such, but did not execute sale deeds but executed agreements to sell a particular flat more than one person, and thereby had cheated the depositors, and the partnership was an unregistered firm and had been.
You come to the para.
Now the prayer, if your lordship.
Para 4.
Para 4. My lord, grateful. That on 27/7/2009, this petitioner and the accused Chandrakant Rai Samantra had executed a land development agreement for development of the said property of the petitioner by constructing a multi-storied building thereon in the proportionate shares of 32:68.
You are a partner with the main accused and you have what?
No, not the partner, my lord.
Documents, and you say very simply that the document.
No, that's a notarial document. That is not a partnership. I gave the property so that I get an apartment out of it. I am also a victim.
In the criminal case, I am not going to decide whether it is a valid document under law or not.
Leaving that
and
apart.
You have invalid document, purposefully have done it.
Oh, my lord.
According to me, so as to cheat the people.
No, my lord, charge sheet has been submitted. I was not found guilty in the charge sheet. But only I am a dupe. I have been as well duped. I am a victim of this.
Why have you not initiated? That's what your
FIR is there.
Complicity is apparently clear. You should have initiated some proceeding against him because he is your partner. You don't want to do.
No, what has happened? This occasion only after the bail order. Bail order of this honorable
Even
court.
today you have not done.
As on today, I have just asked for the property to be released in my favor. That is 443.
Property.
May I pray?
The same property is being shown to many people.
No, not the property. The apartment which he has.
Apartment in the same property.
In the
you are
same
supposed to
property.
be built.
Yes, my apartment has been also sold to another person.
Anyway, because you
So
are,
I am also a victim.
You are
Otherwise-
supposed to be. I don't know. I'm surprised you are how they are not made you co-accused.
No, may I pray?
Hmm.
In such event, what the learned court below has suggested that I may be filing another application after the end of the CNC. CNC is the civil miscase application. May I pray that is taking quite a long time. So your lordship targets that.
CMC? What CMC is more?
Your lordship may see.
Where is that order?
That is page 77.
77.
The operating portion.
Okay, 77. Okay.
Paragraph 4. In the aforesaid backdrop, when the similar petition has already been disposed of in similar capacity and civil miscase number 3 of 2017 is yet to be disposed of, the subsequent petition preferred by the petitioner.
What is civil miscase? What is it?
Civil miscase is that those miscases where the attachment of property can be released in favor of a person and they are to be registered as civil miscase. If somebody is claiming. Yes, those civil miscases, number of civil miscases are pending.
Your case, your property related to 3. 3 of 2017.
Yes, my lord. Yes, 3 of 17.
Legal scrutiny for its survival as such is rejected. However, the petitioner is at liberty to prefer such petition after the disposal of that is disposed of now?
No, that has not been yet disposed of. That is still pending.
No, you call where is
That is for the evidence of the sub collector is pending.
Where is call him? I can expedite it and so that.
My lord, I'll just give him a call. I'll come.
Okay, call him. Yes.
Next one.
Then is that
yes. OPID cases, one parallelly the civil miscase
I
runs.
understand it. The court has given you liberty to revive your application after the civil misdemeanor case. Number 3 of 2017 is disposed of.
Yes.
Now, according to you, it is not moving at all.
Yes.
So at least that is expedited. So at least you can
have
get
come-
your remedy under that.
Well, great.
That
Great.
if you order, at least you can get.
Yes, madam. Great.
Pass over. You are bringing him or I'll next week?
No, I have another matter. My associate will call. Pass over.
47,
yes. 47 plus.
Let him wait, huh? Okay, next, 78.
Made Your Lordships.
Hmm.
Your Lordships, 205 petition has been rejected by both the court below, Your Lordships.
Rejected.
Rejected, Your Lordships. Your Lordships, I am on the ground, Your Lordships. This petition number two is 85 years and 3 is 95 years old, Your Lordships.
95.
Yeah, yes, Lordships. It is arising out a complaint case.
No, no, petition number 1, figure 9 is 75.
He has been died, Your Lordships.
85 and
85 and 95, Your Lordships. And Your Lordships, it is arising out a complaint case and it is very silly offences are there, Your Lordships.
Yes.
Arrangement of complaint case, my lord. Initially, my lord, the notice is go to my lord, if your she wants to send notice, my lord. Otherwise, my lord, I mean, the state is the opposite
have to
to my
issue
lord.
notice. Issue notice next week.
My lord.
Next week.
Next week,
I
Lordships.
issue notice.
Lordships, may I pray, Lordships, interim stay maybe.
Private complaint case.
205 you
Yes,
want.
Lordships.
Why should I stay?
No, I am not, Your Lordships, when he will
I'm
appear.
putting in next week, therefore, because looking at their age,
Yes, Lordships.
I'll allow this
Yes,
205.
yes, Lordships.
I'll allow. Only you file the requisite in
Yes,
the
Lordships.
course of day.
Yes,
81.
Initially, FIR under section 363 of IPC, subsequently charged filed on 363 and 366 and 376 2N and 368 and 109 and 34 IPC and section 6(1) of 17 of postcourt matter. Your Lordship, go to the FIR, answer 1.
Cognizance is taken.
My lord.
Cognizance is only
Cognizance, charge has been filed, my lord. Charge, you have I
Where
have
is the charge?
challenged the 227 of charge, my lord.
Huh?
227, my lord, of CRPC.
Charge has been framed already.
Yes, my lord.
A file revision.
My lord. So that,
File revision.
my lord.
File revision against charge order.
My lord, your lordship, I am rejecting the 227, so that I am going to 48 to file in this court, my lord.
What is the stage? Charge has been framed. And evidence.
Yes, my lord.
To charge.
I know, but what is the stage of the trial? Anyway, why it should be discharged?
My lord. Your lordship, go to the ordership pass in 34th page. On page 35 now, my lord.
Where is
Second
the
page.
charge sheet?
My
Charge
lord.
sheet is there.
Your lordship, go to charge sheet, that is answer 1. That is, and the final form is page 13, 363 and 366 and 376 2N and 34 and 61 and 109 and 368 and 17 of postcourt, my lord. So my question is, the age is 17 and 19, and you also very clearly mentioned page 31, the statement of the victim, my lord. Page 31, my lord. More na Lipsa Maji, like a sweet, boys to 17 ବର୍ଷ.
30?
My lord, page 31.
Okay.
ବୟସ 17 ବର୍ଷ, ପିତାଙ୍କ ନାମ ସତ୍ୟପ୍ରିୟ ମାଝୀ, ଆଜି 9/4/23 ତାରିଖ ଆପଣଙ୍କ ଠାରେ ଏହି ମୋର ବୟାନ ଦେଉଛି ଯେ ମୁଁ +2 ପାଠ ବଇନ୍ଦା ଜନତା କଲେଜରେ ପଢେ। ମୁଁ ଛୁଟିରେ ମୋର ଅପା ଘରକୁ ମାଛକୁଟା ଗାଁକୁ ବୁଲି ଆସେ। ମୁଁ ଆଜି 5 ବର୍ଷ ହବ ଗୁଣ୍ଡାନାଳି ଗ୍ରାମର ମୁନା ସାହୁକୁ ଭଲ ପାଉଅଛି। 5 years back, my lord. ଏହି ଘଟଣା ମୋ ବାପା ମା ଜାଣି ସାରିଥିଲେ। ମୋତେ ମାରିବା ଭୟରେ।
So what do you want to say? She's 17 years.
Yes, my lord. But section, my lord, section 6, my lord, the postcourt, it is difference, my lord. I going to the I only, my lord, read, my lord. ମୋତେ ମାରିବା ଭୟରେ ମୁଁ ମୁନା ସାହୁଙ୍କୁ ମୋ ବଡ଼ ଭଉଣୀ ଯଶୋଦା ମାଝୀକୁ ଫୋନରେ କଥା ଜଣେଇଲି। ମୁନା ସାହୁ ମୋତେ ଘର ଛାଡ଼ି ଯିବା ପାଇଁ କହିଲା। ତାପରେ ରାଜି ହୋଇ ଗତ 19/10/22 ତାରିଖ ସନ୍ଧ୍ୟା ସମୟରେ ଅପା ଠାରୁ ଚାଲି ବାପୁଜୀ କଲେଜ ପଛରେ ଥିବା ଏକ ବେଲଗଛ ପାଖରେ ପହଞ୍ଚିଲି। She has gone to this. The petitioner has no interest and take back him. ସେଠାରେ ମୁନା ସାହୁ ପୂର୍ବରୁ ଗୋଟିଏ କାର ଧରି ଠିଆ ହୋଇଥିଲା। ଆମେ ଦୁଇ ଜଣ କାରରେ ବସି ବନ୍ତଳା ଗଲୁ।
कार ड्राइवर आमको बंतल छाड़ी पकड़ा से मुना सांग बापी भाई आमको एक भड़ा घरे रखाईदेला सेठारे आमे प्राय 6 मास रहिलु आम्भे दुई जन स्वामी सुहे रहिथिलु मुन्ना साहू मो सहित शारीरिक
What
संपर्क
do you want now?
my lord my lord the section 6 the postcard is not applicable in this case my lord your lordship go to section 6 of the postcard my lord
Read it.
punishment for my lord.
Read it.
My lord. Punishment for aggravated punishment for
Read it.
my lord, your lordship.
These are minimum. No, get the book. Let him read. Yes, got it. Yes. Yes.
6-1 my lord.
6.
6-1 punishment for aggravated penalty assault sexual assault my lord. Who
1 minute.
My lord, your lordship.
Yes.
Whoever commits aggravated penalty sexual assault shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment of life, which shall mean imprisonment for the remainder of the natural life of that person, shall also be liable to fine or death, my lord. Here is a my lord, there is no
Penetrative sexual offense.
yes, my lord.
Yes.
Yes, my lord. My question is this thing. Also, your lordship, what the rejection of discharge question, rejection, your lordship go to. The discharge rejection question, your lordship, the para, page 35 of the para second, on page.
What is the meaning of, I stayed with the accused as a wife and husband? What is the meaning of it?
That, my lord, there.
In the cognizant stage, I will bring them and interrogate.
My lord, I cannot say, my lord. Your lordship, the order passed by the lord.
What are you arguing? 6 is not enough this much. For a minor girl of 17 years, 5 years back,
yes,
she says that I went with this boy and he took me to a particular place. I stayed with him for 2 months.
Yes.
And we stayed like wife and husband. Is it not enough for 6?
Your lordship.
Because he has not explicitly said.
Yes.
That there was the intercourse.
Yes. And there is also love relationship, my lord.
Then consent, no consent. 6. Will you withdraw or dismiss?
My lord, your lordship would have passed order. Only my lord.
Why are you wasting? Why are you spoiling your case?
Yes.
Go and cross-examine her. Say that within 2 months, what is the meaning of these are the questions?
Yes, my lord.
Shall I frame the question? Cross-examination question.
Yes, your lordship. Another question. The order. Your lordship go to page 36. The judgment passed by the.
Your first attempt is.
No, you my yes, my lord. Yes, my lord.
Second attempt, you tell
yes,
me.
my lord. Yes,
What
deeply.
Yes.
My your lordship go to page 35.
35, okay. 35.
On perusal of medical examination, the second para. On perusal of the medical examination report of the victim, it reveals that the doctor suggests the age of victim is between 17 to 19. On the perusal of the copy of the school admission register, which claimed to the seize IO from the charge sheet, it reveals date of birth is 5/3/2006.
This is cognizant stage, all these things. What?
Yes, ma'am.
How can I go into all these things? Whether she is 17 or 19, there are some documents. It has to be proved by the prosecution. They may prove, they may not prove. If they don't prove, you will come out. If they prove, then you are in. In the cognizant stage, I will examine it.
That not press, my lord.
But it's better.
Not press.
Better don't do that. If I write something unnecessary, all the argument I have to deal.
Yes, ma'am.
Unnecessary, why unnecessary?
Yes,
Simply, I am saying that to withdraw,
Withdraw.
to
And
raise
leave
all
it-
the points at the appropriate stage.
And liberty to.
Let comes for the petitioner seeks to withdraw this petition to raise all points, issues before the court, before the trial court at appropriate stage. Appropriate. With this liberty, the petition is disposed of, not even dismissed. Okay. Yes, 83.
May I please, Your Lordship, on behalf of Mr. Acharya.
What?
Matter relating to rejection of application under section 311.
PW8,
Yes, Your Lordship.
who is he?
He is the informant and son of the deceased.
What is the offense? What are the offenses?
Offenses, my lord, initially the offense was 307 and subsequently it was
He is
turned
the
to
victim.
302.
He is the victim.
No, initially it was 307, subsequently turned to 302.
Anyway, but he is the PW8 is the
Son of the deceased.
son of the deceased.
Yes.
Show me is the
311 petition page 32, Your Lordship can have a glance.
no. Show me his. Why have you not cross-examined him?
No, further cross-examination. And I have given the questionnaire, Your Lordship, page 32 is the petition. The questionnaire has been mentioned
Yes,
at page 33.
See 302. His right is also there.
Yes.
So single opportunity.
Yes.
Single opportunity.
Yes.
Okay. Right now, the petitioner has challenged the order dated 18/9/2023, passed by the Sessions Judge Baleshwar, whereby his application under section 311 CRPC seeking recall of PW 18 as a PW 8 for further cross examination has been turned down. The petitioner has moved the application under 311 CRPC enumerating the proposed questionnaires. Proposed questionnaires. What was the reason? Why have you not cross-examined him?
No, cross-examination was there, but
why
these questions were not
these
put.
question you have changed the lawyer or what?
Yes, madam.
A wiser lawyer has come. That is what he was. Where is the ground? Just see me. Something I have to write. What is the ground?
These questions which are relevant for the because there
Relevant
was
you should have asked in the first instance. Why have you not asked?
death was
Recall the
there.
time rejected the. What is the reason? You have not given any reason. Why have you not done?
Question उड़ाकर दे दीजिए.
And you are writing the counsel appearing on behalf of the accused person has not asked some vital question to PW18 for which the ends of justice. Why you have not asked whether he was not well or something? No reason.
But in fact, it was originally not adapted in my opinion.
Yeah. And before the court below that the vital questions could not be put to the witness. Could not be put to the witness. Next order. Since the petitioner is facing trial for an offense under section 302, his valuable right of defense needs to be taken care of. Therefore, he is entitled to the appropriate cost examined to the vital witness, namely PW8. Therefore, the petition, accordingly, the petition is allowed. The order dated 18/9/2023 passed by the court below is certified, and petitioner shall be given a single opportunity to further cross-examine the PW8. However, the relevancy of the questionnaires shall be gone into by the court below before summoning the said witness. You'll see the relevancy then. Okay. 84.
Since another item 76 it is arson, non-apostata is it category arson thao. Non-apostata.
Yes. 80. 84.
84.
Maybe. Vacancy order of dismissal of my application to discharge me from the case, my lord, I have a position of court. The fact remains, the affair has been lodged by the opponent 2 with the allegation.
Hmm.
C has prior land dispute with the present petitioner, because it is in her case that before 4 years before there was an agreement between the present petitioner with the informant relating to sale of a land which stands in the record in the name of the present petitioner.
Yes.
And it is also his case that he has given a sum of rupees 50,000, and thereafter petitioner has not agreed to it, and thereafter it is also alleged that some times before the petitioner was threatening to oust from the particular, leave the particular bucket the land, otherwise he will be ousted from the land. So with that,
What is this judgment?
Thereafter, my lord, may see, my lord, may page 6 to 10 are the affair. The relevant part is 9 and 10, that is the written affair, my lord, plain paper affair. Wherein it has been alleged that supporting this, he has said that on the day of occurrence, that is on 28/6/2010, 3-4 persons, unknown persons, they entered inside the house forcibly, and they have also assaulted and taken away some of rupees 70,000 from the house of the informant. And by this person, it is also alleged that they have inserted finger on the private part of the wife of the informant. So with that allegation, FIR has been lodged against the present petitioner, his wife Jharana, and another person, because it is alleged that some days before they were threatening. So with that allegation, the prosecution starts with the case, my lord. Now, in the investigation, it has been found that because of the fact that present petitioner along with another Ramachandra, they were there, they have also threatened, and the charge sheet was submitted against the present petitioner, excluding the wife petitioner, that Ramachandra and 3 other persons who were allegedly went to the house of the informant and somehow made some sort of allegation of rape. And with that allegation, they charged those 4 persons. So sorry, those 5 persons, 3 persons, the person who have committed the alleged rape, and 2 persons who were allegedly went to the petitioner,
along with Section 4 of the DP Act. In the meantime, the matter has been amicably settled. And yes, Your Lordship. And Annexure 2, I have annexed the settlement agreement as well as the mutual divorce application.
Bring them tomorrow.
Tomorrow? वो ढेकानाल रहते हैं.
Settle. Bring them online. I'll pass it finish.
My lord, deeply will be deeply appraised.
At 2 o'clock.
Obliged, Your Lord.
Bring them online.
With joint affidavit?
Yes. Aadhaar card and everything you bring, and so that see, in these kind of matters, in matrimonial dispute, if they settle, close it. Otherwise, something else will crop in. Better than close it.
Highly obliged.
Tomorrow. Yes.
86.
Yes.
May I please, Your Lordship? Here, my lord, the petitioner filed this application for quashing the proceeding under the Domestic Violence Act.
Who are you?
On 30.
What happened exactly? Tell me.
The court below has returned the file.
Okay.
That is therefore the notice.
Let us issue notice.
Notice need to.
So
it was not.
I've already written everything. Around that it does not have a territorial jurisdiction.
Yes, ma'am.
If further submit that, since the complaint is in the advanced stage, the witness has already been examined, and at this stage, the complainant ought not to have returned and petitioner to take fresh step to serve opposite party number 2. Adjourn. Yes.
88.
Yes.
Item 88 permitted to withdraw. I have already filed the withdrawal memo.
Yes, very good, very good.
89.
Annexure 1, page 9, paragraph 3 may be kindly seen, my lord. The bail was allowed by the Honorable Court below, but there is one condition that one solvent surety and he must be blood relative, my lord. The father of the petitioner has died, my lord. There is no other blood relative of the petitioner, my lord.
Where is that?
Page 9, my lord. Paragraph 3.
He shall appear before IO, no problem.
Other conditions are remain intact.
He shall not, which shall not force, which condition?
Not that
First one.
First.
Just number 1.
Release the bail furnishing bail bond of
30,000.
solvent surety, and it must be blood relative and for life. Why have you moved application before court, that court, for change of this condition?
My lord, no. Direct, my lord.
That condition we gave it makes it.
For
Why can't you
39.
go there? It is coming. 400. Kitna tha wo? Condition, altering condition. 1 minute. 400. 420. Here, 420. Where is that provision?
439 1B.
No, there is another provision. You can go to that court also. चलो alter करो. Let release the bail and furnishing bail bond. Solvency he must be a blood relative.
Any local security.
On local security.
Known to the
The
petitioner.
petitioner is agreed by the condition imposed by the court below while admitting him to bail. Admitting to bail. Precisely, he is agreed by the first condition, namely furnishing a bail bond of rupees 30,000 with one solvent surety, and he must be his blood relative. He must be his blood relative. Highlight for this. He must be his blood relative. Okay. Learned counsel, the petitioner submits that the petitioner doesn't have any blood relative in that locality, and he will he is ready and willing to replace a local surety in the alteration of the condition of furnishing a bail bond of a blood relative.
Yes.
With such modification, the petition is next. The petition is accordingly allowed with such modification. Yeah.
90. This is a case, my lords, arising out of 2cc case.
Yes.
Let's kind of a glance to page number, my lord, 68.
Yes.
Let's continue on page 68. This is for
60?
payment of wages and all this.
68.
Minutes. 68 minutes. That is the cause title of the application filed by the inspector of payment of wages. One, of course, it is filed in the name of the inspector itself. It should have been in the designation. But anyway, it has been filed, so I don't want today's on all these points.
Inspector under payment.
Inspector should file. Anyway, matter they have filed it. I'm not on dispute on that. I am concerned about my position. But so far, me, I'm in serial number 3. Defendant number opposite part number. Yogesh. I am declared as managing director. Not known. Was Indian place, Tower C, MGM Road, such and such. I was never there in that organization. I was never there in that organization. I never participated in any proceeding. So where from you got me? And
you are not the managing director.
Yeah, I was not the managing director. I was never the director.
Have you told that in the court?
Yes, my lords. I have told it. My lords, there I filed a petition saying all those things. My lords, the trial court, my lords, that is this is the cause title of that particular my lords, order passed in 2cc case. Page, my lords, kind of a glass to page 69. It starts from page 69. All that I have stated there. The relevant portion will be at page 71. That's the second paragraph.
Third.
Review the case record. The petitioner OP number 3 has not filed any document to show that he was not an employee of Wilt during.
Overall submission only.
I filed a petition, minors, detailed petition.
No petition, but you filed some documents. So that
I have filed documents.
But he says, you know.
No, man, that is exactly what I said.
Where is that? What you have filed?
Well, I have given, well, sir, because if this is a 2cc case, generally we receive summon, my lords. After appearance, we are to be given all the papers, but papers could not be given. That is what we got the certified copy of all the documents. A copy, bunch of the copy I filed at the time of admission. I think might be there in the record itself.
Have you filed these documents before the
Yes,
court
my lord.
below?
Yes, my lord.
Show me where you filed.
Yes, ma'am. These are all matters that is there in this.
My application, show me in the application, your application.
In my application.
Ah.
Yes, ma'am.
Where is your application?
My application something. Well, it's kind level class to annexure 2, page 14.
Hmm.
14 starts from page 14.
Hmm.
Well, a copy of MCA record. MCA means also company's record.
Hmm.
The concerned company's record. Annexure A by 1.
MC record.
Record of Jogeshwar Aguilar, Dean, Director
History of
of
board
Identification Number, Annexure A by 2, A2. Then my lords, Annexure B and C. Then Annexure D. Circular. All that I have stated. There is no dispute on that.
Yes, Mr.
Also, may I submit now only one line? Must be kindly. Thing is that the learned court held that the inspector inquired into and come to a conclusion. Plus, their managed directly for a filing of a reply, and the reply has been filed. Plus, the kind of also that reply.
It is at the summoning stage.
Well,
it is the summoning stage.
Yes.
You have filed reply.
No. The government filed the reply.
Hmm.
On 11/8/2023.
In this case.
Well, in this case.
Where is that? Oh, so many things have come. Yes.
There, what they stated is only one ground. It's a paragraph.
Set aside and send it back to the court below to decide. All the documents are there. Why? What is this? He has said nothing is filed. You have filed everything. And now so many things has come on record. On that basis, let him
In my humble contents of only one thing, my past here also, because there are materials. There they said, the deponent said that the complainant before the STM, means the court below, categorically said that because of the fact that I have been shown as an opposite party in some other case, that is what I presume. That is your paragraph 8.
It's all right. Now everything has come. He will decide. I'll target it and I'll say that within 1 month he should.
No, only thing matters may I point out.
Completely non-application of mine.
Completely non-application mind.
So
Because I am pointing out only one thing. What they said, kind of a classroom matters, what they want to say and how this is contradicted to each other. Well, then matters the government relied upon.
You argue all this point, you will succeed. What is
exactly? Must keep that position.
Everything, all the points which you are arguing, I'm keeping it open. I'll set aside the order and remit it back to the court below, and so that you can argue everything.
Yes, ma'am.
It's a case of complete non-application of mine. He has filed many documents. How can you say that no document was filed? What is this? Where is that order you have shown me?
Well, that order is annexed. Order is annexed.
69,
Page 70, 71, man.
70.
Page 71.
Yes. You have moved the application under section?
Well, so I filed the petition matters.
Hmm.
That petition is petition matters that generally there is no provision there. We filed a petition, complaint case filed under section 15(2). I filed a petition to delete my name.
By the way, who is appearing? Is notice was issued or not?
To me, matters.
No. Opposite party?
The government matters, the opposite party matters, the inspector issued notice was issued and they filed the reply matters.
Yes.
They filed the reply and they have in the reply they specifically contended because of the fact that you have been shown as managing director in some other case. That is what I presume. But that exactly matters. I want to point out that portion only. I think that will suffice my lord's query.
Where is that?
Annexure D by 1 to the my lord's affidavit file.
D by 1.
Well, 16 to 23. Well, 16 to 23, they said that there was another case. Well, that starts from page.
Hon'Ble Mahapatra. Hon'Ble Mahapatra.
Hon'Ble Mahapatra. Well, there, I was shown as Jogeshwar Aguilar, managing director, such and such, Ballarpur Industries.
Okay.
But only thing, my lords, I am to point out, my lords, for my lords' consideration. The reply was not filed by me, nor my lords I have stated anywhere that I am the party. And the
What
reply,
step have you taken in so far as Banwali?
my lords, I was not there. I was not issued any notice. And this affidavit, the reply, what they rely upon, it has been filed by somebody. My lord, kind of a glance to that affidavit verification.
Anyway, I am remanding quite.
Kind of a glance to verification of page 22. Page 22, my lord, kind of a glance to that. One Mohit Puri has filed it.
The petitioner has been summoned. The petitioner has challenged the what have you challenged? What have you challenged here?
Here, my lords, we challenge that I should not be treated as a party. This should be, my implicit should be quashed.
You moved an application
Yes.
which was rejected.
Oh, yes, my lords. My application, my lords, categorically is annexure 2, page 414.
This position. You have been summoned in which case?
Page 18.
Where is the summoning of?
Summoning, my lords. Summoning at page 13, my lords. 13. Annexure 1.
1. Yes. Petitioner was summoned by the court of JMFC 1 Cuttack in 1 CC case, na?
2 CC case.
2
CC case.
CC number 1 of 2022. 1 of 2022 filed by the opposite party under section 15(2) of Payment of Wages Act 1936. The petitioner, while his application dated, no date application.
Date is not there, my lords. That application was filed on, my lords, 31/1/2023, page 14.
31/1/2023. Raised objection to the summoning order inter alia, stating that he is no way connected with Messrs. Ballerpur Industries Limited.
There, my lords, I categorically prayed that.
The 1 minute, however, in the area of the parties, in the area of where is that?
My prayer is page 18.
However, in the area of party, he has been implemented as opposite party number 3, showing as a managing director of Messrs. Ballerpur Industries Limited. Ballerpur Industries Limited. In the said application, he next paragraph, he moved an elaborate application before the court below, inter alia seeking dropping of his name from the area of opposite party accused in the complaint case. In the said application, he has filed as many as he has filed many documents marked as annexures. Marked with annexures to establish the fact that he has nothing to do with Messrs. Ballerpur Industries. He has emphatically submitted in the application that he at no point in time he was associated with Messrs. Ballerpur Industries. Also, notice was issued by this court to the opposite party, and the opposite parties have now filed the reply. In the reply affidavit, the opposite party hearing has contended inter alia that in MJC case number 1/2017, which is pending before STJM bracket S Cuttack, the present petitioner has been implemented as opposite party, and in same case as well, the petitioner has been implemented as managing director of Ballerpur Industry. Therefore, they have implemented in the present case as well.
They presume
implemented in the present case as well. Having gone through the record, I found that many documents were placed on record to suggest that the petitioner is not neither employed nor has any relationship.
No, it's not a director, my lord, sir.
Neither employed nor is the managing, much less as a director, managing director of Messrs.
Managing director, will.
Managing director, managing
Direct, I was not a director, even.
managing director inside, na?
Like how is managing?
Managing director of Messrs. Ballarpur Industries Limited. The while dealing with the application of inter alia recorded agenda. Recorded agenda. ये para
Page 71, so paragraph 2.
page 71 para heard the peruse the record the petitioner so rejected. You put a paragraph, huh? Heard rejected being devoid of merit. Page 70. I'm of the considered view that the court below has failed to consider the court below has ignored the various documents placed on record by the court by the petitioner and written a finding that no document whatsoever is placed on record. This part of the order of the court below is smacks a complete non-application of mine, non-application. Therefore, I am of the view that the impugn order is liable to be set aside and the matter is relegated to the court below for reconsideration of the application afresh, taking into consideration all the documents and amendments made in the application. The parties are left. The parties are given liberty to raise their respective points before the court below, and the trial court to decide the matter afresh without being influenced by any observation made by this court in this order. In this.
Another exact manner, but I submit manner. The opposite party was an employee of that.
I kept it. He says he has filed many documents.
Many documents to show that he was not an employee of a
Anyway, you argue all this before trial. Trial court has not considered anything.
Employee, so far employee,
whatever you are prosecuting someone under section 15.
That's true, man.
You need to address everything. All the documents. See, every documents are filed.
No. Trial court stated that the petitioner has not filed any document regarding whether he was an employee or not.
He has filed.
He has not filed manner.
Anyway, you are tell. I have only said that not influenced by the observation made. A fresh
May I only just add one thing, my with the humility, what my learned friend says. Suppose I am an employee, I cannot be held liable. Only if I can be a managing director, then you can hold me up on section 15.
Lower court stated that.
How come? That is what is
they want to promote you to managing director.
Exactly, my lord. That is the thing. If you say that I am an employee but not a managing director, then also proceeding against me is not meant.
Okay, now you treat yourself as managing director.
Yes. If they will be going on paying that is what the thing is.
Argument? Yes.
My lord, item 91 kindly urgent to accept it, Mr.
Give Mr. Das. I will indicate a time frame also for disposal of the application.
No.
Otherwise, it goes. In view of the fact that the complaint के file करते ले?
Your job, I should.
In view of the fact that the complaint was filed
in the year that was filed 2022.
CC case number 1 of 2 to avoid further delay in the proceeding. It would be appropriate that the trial court should decide the application as expeditiously as possible, preferably within 2 months. 2 months? Yes.
My lord, senior counsel appointed as election officer of this High Court Bar Association. So, my lord, today he is busy with some work. Kindly adjourn to 2 weeks up.
He will be busy till the result. Okay. Adjourn. 92. And we see till next week sometime. Okay. At 4:30 I'll have to close. Entry mode to continue. Yes. He is giving a date. Yes. 94.
On 94, arising out of 138 of NI Act, we have already settled our issues. I paid the entire amount. Annexed to 2 is the agreement.
What?
I have received all the amount.
File the affidavit.
Yes,
Tomorrow.
The affidavit is there in Annex to 2 miles. It is 22.
But where is the parties? Tomorrow they should not make a, allegation against you people.
No, I have given the DD. I have given the copy of the DD, demand draft.
A demand draft you.
Annex page 26.
Okay.
Page 26.
Okay. Where is that? Page 26.
Page 26. 2 lakhs.
1 million. Yes.
And that is
what was the check amount? 2 lakhs only.
1,53,000. I paid 2 lakhs.
Okay. The petitioner has filed the present petition seeking quashing of the ICC case number 40 of 2007 pending before the court SDGM Jharsuguda.
In city case
in 138 NI Act. Notice was issued?
Yes, ma'am.
A notice was issued to the opposite party number 2. Opposite party. 2 or single opposite party?
One.
Opposite party.
Opposite one.
Opposite party number 1. Who is the complainant? Complainant. Next part. Parties have settled their dispute and entered into an agreement dated 25/6/2022, which is placed on record. Pursuant to the said agreement, a demand draft of rupees 2 lakh. Where is that?
26.
2 lakh.
That is also placed in
2 lakh has been paid to the complainant, and photocopy of the said demand draft is also part of the record. Part of the record. On the basis of the said settlement, the petitioner is seeking quashing of the entire proceedings. Mr. Das appearing for the opposite party number 1, being the complainant, endorsed the fact that he has received the draft as per the settlement, and he has no objection in quashing the proceedings. In view of the aforementioned, the MC, what is this?
The CP
CRLMC number 5482 of 2023 is allowed, and the CT case number
40 of 2007.
40 of 2020.
Arising out of 1 CC case of 2007.
Arising out of 1 CC case number 40 of 2007, pending in the court of SDGM Jharsuguda is quashed.
Right.
Okay. Some other day only.
Bail application.
Tomorrow, bail application. Bail application tomorrow, the other one. Yes.
Pardon, your lordship. Item number 10, my lord, I missed that. Next week, your lordship.
Why do you have the luxury of coming at late?
My
Why
lord,
can't you come in the first hour? Youngsters should come at least.
my lord, at 2 p.m. a matter fixed before Honorable Court.
I'm talking about before 2.
Another matter is
Before 2, I'm talking about. 2 o'clock, all right. But before
another matter is there. So for that reason.
another one matter,
One.
you ignore this. I give a date, short date, because
My lord, the matter adjourned to 7th May. It is a bail matter.
Giving longer date. Somebody who doesn't appear.
Oh, if somebody doesn't appear,
My lord,
the board is so heavy, so I'm adjourning it for a longer time.
Your lordship,
Instead of dismissing in default.
Learned
Because the
State
moment I
Council is,
dismiss in default, application will come. Wastage of time.
my lord, Learned State Council is fully prepared with the brief. Just, I will take 5 minutes for this.
He only suggested to give it in May. What to do?
May
Just adjust. See,
Next week, your
bail
lordship.
matter for tomorrow. Bail matter for tomorrow, and rest will.
My lord, my lord.
94.
Sorry to disturb again, my lord. 77, Mr. Bhuya's name may be reflected. Then he's
77 Bhuyan's name, because he has partially argued and give a short date so that the proposition which is given.
Item 94 urgent copy.
My lord, lastly, item 6 also adjourned to next week. 6 is similar, not similar, but
6 and 6, same.
My lord.
Issues is same. I.
Grateful, your lordship.